Good morning, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. Let's start our day with Judge McNally.
F244672. Ma'am, can you tell me your name, please?
Deborah Ann Lennon.
Attorney Mike Baldwin, House Counsel P 65417 on behalf of Ms.
She pled the retail fraud. The agreement was it would be taken under 771.1. She was referred for a pre-sentence report. Have you had a chance to review that report with her, and are there any material additions, corrections, or deletions?
Yes and no.
Okay.
Very briefly, Your Honor, my client has one prior driving related offense about, I believe, 20 years ago. But aside from that, she has no marked criminal conviction history. One of the things that stands out with my client from day one, and now that she's fled, I can say it, is she's disgusted with her behavior. She is really being hard on herself. And that's important because it shows that she cares. She cares about herself, about her personal dignity, about her impact on society when we talk about property theft crimes. And I feel that she's going to be a very good candidate for the delayed sentence. She is actually, I think, is being harder on herself than the court could ever be. And I trust that she is remorseful, and I do not expect her to behave this way again. Moreover, I do believe that provision 3 of the recommendation is paramount to ensuring that she have a psychiatric evaluation for mental health considerations to maybe get to the question of why she did this, and leave it to the mental health professionals. I have nothing else to add. I think she'll do well, and I wish her the best.
Anything you would like to say, ma'am?
No. I don't know, sorry is the word for it. I just, I don't want to go through this again, and I swear to God, I will never do it again. I would like to look into why I even did something like that. I don't know if it's depression or what it is, something's not the same with me. I'm willing to do whatever will prove that I won't do it again.
Have you ever gone through mental health treatment? You think you need to see a professional?
I don't know if it's like mental, but I've been going through a lot personally and suffering with, I seem to think some kind of, I don't know if it's depression or what, it's just the way I feel about life has just been different.
So you want me to order you to go through a cycle?
What does that entail? I don't understand.
You can do it on your own if you wish. The judge is asking, would you like the judge to order the court to order you to do it?
You know, I mean, I don't usually,
What is-
listen, just let me finish a second. I don't usually leave it to defendants to sentence themselves. Okay? But you're 64, 5 years old. You had the drunk driving that you were convicted of, the impaired in 2002. I read your letter that you sent me. You sound remorseful. Everybody makes mistakes. I'll be happy to order you to undergo psychiatric evaluation if you want me to. Otherwise, I'm not sure it's necessary, but I will do that.
No, I think I would just wanted the sources for someone, for me to be able to talk to.
Your Honor, I think that is a very good point, that if it's court ordered, there are public resources through our
How
government.
about if I just order personal counseling? That's what I'm.
You have insurance
No.
there. if you order, I think we may be able to utilize the public resources that are available through the probation department because she doesn't have, you don't have social security.
Calling Jessica real quick. Please.
This is here just started, so I don't have all
The benefits.
Right.
Okay.
Let me leave that until I talk to probation, okay? In the meantime, have I let you finish with everything? I'm sorry. I'm speaking low. There's nobody else in here. I apologize. I'm gonna call probation. I'm prepared to go start your sentence. I want to talk to them about what would be available. And we'll go from there. Is that fair? Do you want to say anything else?
But I'm sorry.
You certainly seem remorseful about the whole thing. Like I said, I read your letter this morning and, I'm gonna go ahead and place you on probation for 6 months. They recommended 6 to 12 under section 771.1. This will be dismissed if you're compliant. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. Your name?
Jessica O'Donnell on behalf of probation.
Do you recommend, they're recommending psychiatric evaluation. I don't know that it's necessary. She doesn't have a lot of resources, it sounds like. She has no insurance. You're not on Medicare yet?
No.
Not yet.
If I ordered personal counseling, is there somebody that's going to pay,
So she can call the 1-800 number, the Detroit Wayne Mental Health Authority, and they may be able to assist her with that, given that she doesn't have insurance.
I'm not gonna order it, ma'am. If you want to do it, you do it, okay? You're not to enter 27327 Telegraph, Flat Rock, or any other Dollar Tree store. You're to serve 4 hours of community service. I'm gonna give you until November 20th. Pay fines 50, costs 50, 75 victims' rights fee, $50 justice assessment for 2 1/4. I'm not gonna charge you attorney fees. You don't have the funds. $60 screening fee for 285. Probation fees are 120 for a total of 405. You pay that, you stay away from Dollar Tree store and any other Dollar Tree store. And you come back on your review hearing date, you do your 4 hours community service, prosecutor will move to dismiss, and I will dismiss. Do you understand all that? All right. If you violate, your probation could be revoked. Your 771 status revoked. Conviction remain on your record and you'd be subject to a 90-day jail term. You have 21 days to appeal this. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand?
Yes.
Okay. Do you have some of this money to pay today?
How much is it?
405.
I have half to it probably.
You pay $200 today.
And where would I pay the rest? Because I get my social security like in the middle of the month.
Okay. You pay $200 today, you pay $50 monthly starting October the 20th. We'll make it the 25th, okay? Okay, wait a minute. And the 25th of every month thereafter until paid in full. If something happens, you don't have the money, you call the court, we'll go on Zoom, or you can walk in here on or before any due date, 8:30. I'll be more than happy to give you an extension. I don't care how many times we have to do it. Just don't ignore me.
Can we set the date, Your Honor?
Yeah, I'm sorry. Thank you. Lisa, what about you?
March 19th of 26 at 9 o'clock.
March 19th at 9 o'clock, March 19th of 26 at 9 a.m. So you'll go down the hall, you'll pay your 200, you'll get your notice, you'll go over to probation, you'll be instructed, okay?
And they'll explain how to, you just go to the clerk to pay.
I'm gonna trust this is never going to happen,
Oh, no.
okay? All right, good enough. Good luck. Thank you. Thanks a lot.
Good morning once again, everybody. Welcome, excuse me, welcome to the Courtroom Files Live. Happy Thursday. Let's stay in the area, but we're going to go into Detroit. Crazy Judge Bryant is online, which we don't often see, so let's see what's going on there.
Oh, I'm going to say it's actually Mr. Nelson Stockdale Garay as the individual assaulted and or assaulted him back. All right. which
No,
individual?
ma'am, do not unmute your device. Do not. Now, Ms. Coleman, do you want to speak to her in the breakout room right quick? Cause it's time for my case. I need to go to my.
No, we'll just go with Miss Lemon as the complaining witness, Your Honor.
Miss Coleman, here's the thing. All right. Today is the date set for pretrial and the THEE complaining witness needs to be present, and we need to know who the complaining witness is. We can't say we're gonna go with this person, but then this person is complaining witness. Who is the complaining witness? Who is Mr. Counsel, how do you pronounce your client's name?
Gansar.
Who is Mr. Gonzar accused of assaulting? That's what we need to know. So do you need to go in the breakout room with either one of these people so we can determine who the complaining witness is so that I can proceed?
That would be best, Your Honor. My report has them both listed for the one incident,
All
and I
right,
know
well,
the
then,
court statement.
I will put you both in the. Okay, I'm gonna put them in breakout room number 19 because Mr. Stockton was already there. Let's move them to number 20, and then can you ask the person that's in 20 to please come out? Can you ask the person in 20 to please come out of the breakout room?
I have that the complainant.
Miss Coleman, there's someone in breakout room 20. Can you ask them to come out?
Yes.
And everybody else, please go into breakout room number 20 that I just gave you the prompt.
Thank you, Your Honor.
All right, while she sorts out what she's actually doing, let's take a minute and go to Miami-Dade. We have a substitute judge there. This is Christina Rivera-Coria, kind of a younger-looking version, perhaps, of Judge Glazer. Let's see what's going on there for a minute.
These are reports. Right? All right, we'll see you then. Do not fail to appear. I'm ordering you to appear. If you fail to appear, bench warrant can be issued for your arrest. Do you understand?
Yes, I do.
What do you want me to do with the priors? The G file.
Yeah.
And next week, Genesis Para on case number B25-22100.
She's out on felony bond F25-15972 Alpha.
The court will place a hold for bond review by the circuit judge. She also has B25-15899, which is open. And appoint the public defenders provisionally on all cases and probable cause being found unless otherwise stated. Good morning, Ms. Para. You are charged with one count of petty theft, misdemeanor in the second degree on October 1st of this year. State, is there a stay away order? Oh, here it is. Okay. From 33501 South Dixie Highway. What location is this? State? A Walmart, looks like.
Walmart.
And in B 25-15899, the court has a readout. It's an add-on. There's also for a petty theft. State, do you have the location of that petty theft in the case ending in 899?
I can get that. One moment, Judge. The address here, I'm not seeing what the name of the store was, but it was another charge, and it's from 21151 South Dixie Highway.
Do you know if that's a retail location?
It is. I'm not sure what the actual name of the location was. It does say it was shoplifting, it was merchant.
And what was her prior form of release on that case? Right, the court is taking her into custody on B 25-15899. And issuing $1,000 bond.
1,000 on which case? The one ending
On
in
B 25-15899. Or the new case B 25-22100, probable cause having been found. Or another petty theft. And with regard to her new case, let me take a look at her priors. $1,000 bond on B 25-22100. And I'm also issuing a stay order from the Walmart at 33501 South Dixie Highway. Do not go back there, otherwise you risk being rearrested. And if you're held in contempt of this court's order, it's punishable by up to 60 days in jail. Do you understand?
Yes, ma'am.
Okay. Next, we have Natasha Sylvie. Good morning, Miss Sylvie.
Okay, I think Judge Bryant's got her stuff sorted out now. Let's find out.
Yes, Joe Varkatise.
Thank you, Mr. Tyus. Have you spoken to your lawyer this morning?
No, ma'am.
All right. Mr. Flanagan, please change Mr. Tyus's name. And then as soon as your lawyer comes, we will be ready. I'm going to put you back into the back into the waiting room, Mr. Tyus, and then we will be with you shortly.
Thank you, Your Honor.
You're welcome. And the person identified as Shemaiah Simpson, please unmute and state your name.
My name is Shemaiah Simpson.
I'm going to send you to a breakout room, Miss Simpson, and someone will be in to speak with you shortly.
Thank you, Judge.
You're welcome.
I lied. She does not have stuff organized yet. All right. I really want to show her, but she's got to get her stuff together first. Let's go back to Judge McNally.
So for purposes of arraignment, does she stand mute and waive formal reading? Yes. I'll enter a not guilty plea, and now I understand that you pre-tried the case, so I'll take the plea, I'll set the bond, we'll set it for sentence. Fair enough? Yes, sir. Ma'am, if you plead guilty to malicious destruction of property, I'll take this under the provisions of MCL 771.1. I'll place you on probation, set terms and conditions, and if you're compliant at the end of that period of time, that I will set between 6 and 12 months pursuant to the stipulated plea agreement, the case will be dismissed as long as you're compliant. You understand that? And did you sign, read, and understand an advice of rights form here this morning?
Yes.
If you plead guilty at any time, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
To the charge malicious destruction of property, how do you plead? I can't hear you. Were you on Gibraltar Road at or near 24953 Mayfair in the city of Flat Rock on September 5 of 25 at 6:11 in the morning?
Yes.
And what happened that makes you guilty of this? Malicious destruction.
Yes. Busting out car windows. Busting out car windows.
Did you know the individuals whose cars you were breaking the windows on?
Yes. Pittsburgh's boyfriend.
Ma'am, you gotta keep your voice up.
That was Tony Pittsburgh's boyfriend.
And so you accompanied her and you assisted in, you busted out some windows yourself?
Yes.
With what? Are you on probation? Are you on probation? Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted to malicious destruction of property. You were drinking alcohol that day, correct?
Unfortunately, sir, yes.
All right. I'm gonna give you $1,000. I'm accepting the plea, referring you for a screening. You've been drinking, so there's going to be a screening and assessment done.
Okay.
I am going to set a bond of $1,000 personal. You don't have to post any money, no contact with the victims in this case. Denolius Buchanan, and also Jewel Buchanan. You cannot have any contact with prosecution witnesses except through your lawyer. You're not to leave the state without the consent of the court. You're not to violate any law. You must appear in court as directed. You're not to enter or go near 24953 Mayfair. Do you understand that in the city of Flat Rock? Also, I'm going to go ahead pursuant to the agreement and dismiss the civil infraction charge on motion of the prosecutor of the CCW charge. So that will be dismissed. Screening and assessment is ordered. I'm going to give you a date momentarily to come back for sentencing.
October 16th at 8:30.
Okay, ma'am, October 16th at 8:30. So you're going to go down the hall. You're going to get your paper notice. And you understand this is contingent on you paying restitution, correct?
Yeah.
You're going to have to do that. October 16th, 8:30. Go down the hall, ma'am. They're going to give you a copy of the bond sheet. They're going to give you a new notice, and then you're going to walk across the hall to probation where you will fill out a questionnaire and be interviewed. Do you understand that?
Yes.
You got warrants out. You might as well start taking care of those.
Okay.
Where do you work at?
I work at the Michigan Veterans Home.
Lisa, I don't know. Oh, she has been printed. I see it now. Okay. Anything else, Mr. Carmen?
No, sir. Thank you very much.
Thank you. Good luck to you, and we'll see you back here for sentencing. And
All right, let's move from Judge Dad to Judge Mom. See what's going on there this morning.
Baker has to unmute first. Hold on, Mr. Baker has to unmute first. And I don't think he understands that he can push that button, so I think we have to wait the 30 seconds for it to unmute on its own. Okay. I think so. Bobby, can you hand me a felony court appointed form, please? I'll just complete it. This is arraignment only, correct, counsel?
That's correct, Your Honor. And it appears that he has been read out, or at least under the 180 days.
That's correct. I see the 180-day notice that was dated August 4th of this year.
Kristen.
Thank you very much. All right, sir, your name for the record, please. Mr. Baker. Mr. Baker. Mr. Baker. Am I muted? No. Mr. Baker. Mr. Baker, will you please state your name for the record? Mr. Baker, can you hear me?
Yes, I can hear you now.
Okay, please state your name for the record.
Donald Baker.
Okay, very good. And counsel?
Your Honor, John Goldthorpe, P. 30758 on behalf of Mr. Baker. Mr. Baker is here present via Zoom from the Jackson prison for the purpose of arraignment. I have discussed charges with Mr. Baker. At this point in time, he would waive a full reading of those charges, stand mute to the charges, and ask for a plea of not guilty be entered.
The court will waive the formal reading. Sir, you do have the right to have an attorney represent you. If you cannot afford one, you may have one appointed to represent you. And the court has signed a petition for appointed attorney for felony matters. And the court will note defendant is in custody at Robert G. Cotton facility. The court will also note, sir, that you do have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
The court's going to enter a plea of not guilty for purposes of the arraignment. Schedule this matter for probable cause conference on October 9th at 8:45 a.m. And then counsel, we have to address bond, but I'm not presuming your client is in, as your client's in Robert G. Cotton facility, I presume he's not going anywhere between now and next week.
If I may.
Yes.
He's in that facility on his statement to me that on a previous occasion, he was charged in Livingston County with this identical charge. He is now in the sentence for, I believe, he quoted 37 months to 37 months to 15 years, I believe. And that's why he's in the jail. The reason he did not appear originally, Your Honor, was because he was in the Cotton facility as of July 3rd. In fact, he was supposed to be here. For those reasons, Your Honor, I would suggest that at least some reasonable bond under the circumstances be set, though he is going to be incarcerated or convicted.
And what is it he's in custody for again, counsel?
He has told me that he pled guilty or was found guilty of charges dealing with, larceny from a building and as well as the stolen property charge.
From this case or?
That's what he said, Your Honor, but that doesn't. I told him that that would be an issue that had to be raised by his felony attorney. And that's why we stood me.
Well, perhaps because your client's been charged with a number of larceny in a building charges, perhaps your client is getting those confused.
He may be your.
Because.
Ma'am.
Sir, I was going to give you an opportunity in just one moment. But what I'm looking at is I'm showing there are sentencing dates in 2022 for 2 to 4 years, 2023, 1 year, 6 months to 4 years. That was February of 23, also larceny in a building.
Correct.
Another larceny in a building with a HAB 4th, July 11th of 2023, 1 year, 3 months to 15 years. Those are all prior to the offense date on this one of March 31st of 25. So, and then there's obviously larceny in a building, habitual offender, 4th offense back from 2011. But
I believe the offense date on this one was March 1st.
well, I'm showing on here March 31st, but let me,
Okay.
March 31st, yes. Okay. Yes, Mr. Baker, what would you like the court to know?
Ma'am, I was convicted on this charge, this case, July 31st. I got 47 months to 15 years. And then after I got convicted of this case, y'all came up with a court date for August the 1st on this matter. I had already been convicted January 31st of this matter. I'm in prison for it right now, a blue Cherokee. I got caught in Livingston County.
All right. Well, here's, let me look at something here. Okay, Livingston County was April 1st of 25 was the arrest segment. June 27th shows the judicial segment whereby your client pled guilty to felony receiving, concealing stolen property, motor vehicle, second offense notice, and felony financial transaction device, 2 counts of those. And then that shows 47 months to 15 years.
That's correct.
All right. Now,
Why he's in Jackson right now.
then there is one from 6th Circuit from 2023, February of 2023, larceny building. Your client pled no contest to, showed 18 months to 4 years.
That's correct.
So, I'm not showing anything yet as it relates to
This matter.
this matter.
Mr. Baker has related to me that the charges that he pled with Livingston County with the 47 months was this case. I'm just telling you what he said. I have not seen the write-ups for any of that information, where I've indicated that set this for a PCC, and if there's a double jeopardy issue, then that will be addressed at a later date.
Receiving and concealing.
So you have a number of those charges in a number of jurisdictions. So it's possible that somewhere that was confused because I'm not even showing anything in the charge segment. But that may be because your client hasn't been fingerprinted yet on the on the Wyandotte felony. Because
Excuse me, Your Honor, can I say something?
just for a moment, sir. So the warrant was authorized by this court, authorized on April 4th by the Wayne County Prosecutor's Office of 25. And then in this matter, June 16th of 25. And that was the complaint and warrant. And then this was never, I don't even think this was ever on the docket here. It was on the docket for August 7th.
That's correct, Your Honor. That's
So
jail.
I understand that, but my point is that this was never on a docket in this court to have been addressed with Mr. Baker when he was in custody at Livingston County. So perhaps he may be mistaken as to these charges. So that's something, sir, your attorney is correct. Your attorney that will represent you at the next stage of the proceedings will address.
Okay, ma'am, can you make sure I'm in person? Can you make sure I'm in person? I can have all my paperwork stuff. Cause I'm not confused. I know what's going on. It's only one person. I think her name was Sharon or something. I've been convicted of this crime already. I'm doing 47 months for it. The Wyandotte case, I got all the police reports. I got everything. I've been convicted of it. The car came up missing in the parking lot, some parking lot at Henry Ford Medical Center or something like that. I've been convicted of the crime. I pleaded guilty to the crime along with my financial transaction advice. They charged me with receiving and concealing stolen motor vehicle, gave me 47 months. So
well,
I would like to be here in
enough, your
person.
client's accurate with what the police report says.
I agree.
Y'all tried to press charges on me after.
Hold on, let me clarify, sir. Let me clarify. The court does not press charges. So when you're saying y'all press charges, the court does not do that.
Okay, where they put a warrant out on me after I was already in custody. I went to jail April 1st in Livingston. After you found out I was in jail, you put a warrant out. The court put a warrant out for me. They never came and got me from Livingston. Livingston ended up convicting me, giving me 47 months.
That may have
for the same crime.
Hold on just a moment. However, sir, let's clarify. You were on parole for larceny of a building out of Lansing, because it shows you were a parole absconder from Lansing Tether Unit. So perhaps there was a plea of guilty on the tether violation or the parole, or maybe you were remanded back to custody for that violation. But I'm unsure of what that is. And I can request that it be in person, but I don't know if MDOC will transport you for a PCC. That's up to them.
Okay. I would like all my matters in person, ma'am. This Zoom don't help me with nothing.
All right. We'll do it in person. You're requesting in person and not consenting to Zoom for the next proceeding, then we'll do it in person. No problem.
I grabbed the wrong envelope. I could have brought it to you. I grabbed the wrong envelope.
Bailey gifts 5 memberships. Thank you so much, Bailey. Appreciate that. Appreciate all the support you give the channel. By the way, you can see Bailey tonight along with Ashley and Michael and myself on Sidebar, where we're going to discuss jailhouse lawyers. So that should be fun. Be sure to tune in 8 p.m. Eastern, 5 p.m. Pacific. And you know what I like about this community? All of you out in the chat were thanking Bailey for just donating memberships to this channel. The fact that you are all so thankful and supportive of each other means a lot. So thanks. Back to Judge.
Will order no contact with the victim in this matter. And the court's going to also, you're serving time, you're currently in custody, but the court's going to order a $50,000 cash bond. so that we have a bond listed. And I did put in here, sir, that you're requesting in person. So we will see you next week.
Okay, thank you.
Thank you. Have a good day.
You too.
What's that?
All right, in our continuing efforts to bring you 9 to 11% more Judge Boyd, let's go to Texas.
For the state.
Good morning, Your Honor. Christian Newman on behalf of the defendant, Mr. Mendez, and he is present today.
And are you Mr. Mendez? All right, we're here on a motion to revoke. The defense has filed a motion to set bond. The court is making an assumption. If it's incorrect, let me know. I'm assuming he's remanded without bond because there's a motion to revoke. Is that correct?
That's correct, Your Honor.
And for no other reason?
Correct.
All right. So, state, are you prepared to proceed on the motion to set bond? And it's the court's understanding that you all have agreed to a bond amount of $40,000?
Yes, Your Honor.
All right. For the record, the court is aware of the defendant's issues as far as setting conditions for bond. So this is what the court will do. The court will set your bond at $40,000. The court is going to order 30 sober meetings in 30 days. And there's one other thing that I need to ask. Mr. Mendez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, Mr. Mendez, since you've been on probation out of this court, have you had any type of mental health treatment? Have you been taking any type of mental health medication that has been prescribed? All right, thank you. All right, the court was then, as previously stated, the bond will be set at $40,000 and you're to complete 30 sober meetings in 30 days. Miss Ferguson, I need a reset for 20 days for a contested MTR. And if it's not contested, counsel, let us know.
Will do, Your Honor. Thank you.
All right, what date?
Judge, you said 20 days?
Yes. Oh, and I'm sorry, state, you may be excused.
I can do October 23rd.
All right, so we'll be back here on October 23rd. If you'll give him a reset form, please. Thank you.
And one question, Your Honor.
Yes.
I did let him know today that because of the warrant on the MTR, he'd probably be taken into custody. We were going to ask the court whether he would be allowed to process through satellite or if he needs to go to the jail to process out in custody.
You'll need to talk to the deputy about that because they now have different rules that there's certain offense you're not allowed to process out from the court. But the deputy will be the best person to answer that question.
Thank you,
Okay,
Judge. Appreciate it.
And Norma, you said October when?
23rd.
All right, thank you.
May I be excused to talk to the deputy?
Yes.
Thank you, Judge.
Have a seat, sir.
Okay. Next is the question. Later today, the wife's going to go over the bonds. Thank you.
Mr. Newman, can you have your client sign?
Sure can.
Just-
Okay. Yeah.
All right, that was a short hearing. Let's head back to Judge DeSanto.
As well, okay? Let's go on the record in the matter of the state of Michigan versus Frank Christopher, 2511130, 251394.
Good morning, Your Honor. Kathleen Tulas appearing on behalf of Mr. Christopher. I was
Thank you.
appointed to his second case this morning.
Oh, very good. I'm glad they were very quick about that. Okay. All right, Mr. Frank, your name for the record, please.
Frank Christopher, Your
Mr.
Honor.
Christopher. Shoot, I'm so sorry. I'm sorry. Can you repeat that, sir, please?
Frank Christopher, Your Honor.
All right, and council, today is the date scheduled for the probable cause conference on the new case 1394. And then we reset the preliminary exam last week to be a PCC on this date to coincide with 25-1394.
Yes, Your Honor. At this time, I am asking that both matters be set for an in-person examination next week. The prosecutor has said that he has sent me all the discovery on both cases, so we should be prepared to proceed next week on both cases. Also, I would like to address bond for Mr. Christopher.
Okay, so let's do October 9th on both matters.
Your Honor, I have a court date in Third Circuit on October 9th.
Well, then council, we're going to have to do this on the 16th.
They won't be able to do anything until you're done. They're waiting for you. Could we go any sooner? It's not possible. I don't know.
Who's waiting for this court? The Third Circuit Court is waiting for
Yeah.
this court?
Yes, that's what he said last week.
Your Honor, the probation, Mr. Christopher has a probation violation. Nothing will happen on the probation violation until this case is resolved. Both of these cases are resolved.
Okay.
But if he has a court date there next week, they probably will still want him for that court date.
So council, can you communicate with the probation department to have them move that date to another date so we can have this exam on the 9th? Because otherwise it doesn't seem to be productive to have Mr. Christopher go to the Third Circuit Court for a probation violation if it's pending the results of these two matters here in this court.
I can contact the court and ask, Your Honor. We can set this for next week, and then if there's an issue with it, then we'll schedule it for the 16th.
Okay. So council, can you just please communicate with us so then we know what's happening with that?
Yes, Your Honor. As
Okay.
soon as I have a reply, you'll know.
All right, thank you. What time, Allie?
Can we do it at 11 a.m.?
I was actually just thinking the same thing. So let me see what Allie says. Well. Okay, 11 a.m. We have one scheduled 11 a.m., one at 11:30, and one at 1 already that day. So whichever is ready first will go, I guess. And then, so council, a couple things. It's also a bond violation hearing as well, because your client was out on bond on a tether, and because he received new charges, your client, it's a violation of his bond as well. So we can adjourn the bond violation hearing also to next week. And council, I'm going to presume that the bond that you're wanting to address is the bond that this court ordered on case 251394, which this court ordered $100,000 cash bond, no 10%, no surety, not to possess or consume any alcohol or drugs. Is that the one you're asking about?
Yes, Your Honor.
Okay.
I do believe that bond is excessive. I do not have all the discovery, so I do not know everything about the new case to argue any facts of that case. But Mr. Christopher has been trying to get his drug issues under control. He was at Sacred Heart. He has a very, very supportive family who support him totally and completely. I just ask if you would consider reducing that bond.
Here's the issue, counsel. Your client is currently on probation for a possession a felony possession charge. He's on felony probation. While he's on probation, he's charged with possession of controlled substance and assaulting, resisting, obstructing an officer August 1st. This court, despite that your client was on probation, ordered $20,000 personal bond. Your client was to be tethered to treatment through the Wayne County Jail. I'm not sure what happened with that, whether he was tethered to treatment or not. Sir, were you tethered to treatment in August through the Wayne County Jail or no?
Yes, Your Honor. And then I went to Sacred Heart August 11th, and I was released on August 29th.
All right. Well, then while your client was out on bond, now he's charged with another felony possession charge. And that is why this court ordered $100,000 cash bond, no 10%, no surety, because quite frankly, it's in your client's best interest and for his own safety and health to remain in custody at this point. The court will also note for the safety of the public as well. So for those reasons, the court's not going to reduce the bond. The court's going to continue bond and conditions.
Your Honor, may I speak a second?
Yes.
I don't know if it's relevant. I just wanted to let you know what happened at Third Circuit last week. The probation department recommendation was for me to do in treatment, return to Sacred Heart. And that's all I'm hoping for, is to get help, more help. And I don't know if it matters. I just wanted to let you know that that was their recommendation, and also that I would be, that doesn't mean the judge will take it. And also that I would report twice a week when I did get out of jail or prison, whatever. And I would report twice a month, every month, and I would be drug tested every time and all of that. I just for your information, that's all. I'm sorry.
All right, thank you, sir. And the court will note that that quite possibly could be something that occurs after the preliminary examination, but I am continuing bond and conditions today.
Thank you, Your Honor. Mr. Christopher.
Thank you.
Mr. Christopher, I do have a jail visit scheduled tomorrow so we can discuss the new case.
All right, and then just one more thing, witness and exhibit lists are due October 6th. We'll see you back on the 9th. Thank you.
Thank you. Everyone have a wonderful day.
You as well.
Thank you.
Okay, we'll return to Judge in just a minute, but before we do, I do want to take a moment to discuss the sponsor of today's show, and that is Aura. You've heard me talk about Aura before, but I want to emphasize the importance of your data online. Aura watches where your data is online. They remove it when necessary, and they do a job that, quite frankly, you cannot do alone. There is a saying that if you get a product for free, you are actually the customer. And think for a moment about all of the things that you get online for free, the websites that you visit, the things that you use, the apps that you have, all of it. It is all tracking your data. But the question is, what happens with that data? Well, I wasn't real clear on it until I started using Aura, and I'm just looking at my dashboard right now with Aura. There are 74 different data brokers now that they are tracking for me and removing my information from, and if it pops back up in those data brokers' databases, which it has on occasion, they remove it again. It is a constant game of whack-a-mole that they play for me, and the bottom line is you have to have it. You have to have somebody out there watching your data at this point, because it is everywhere. And if it gets in the hand of bad actors, which it certainly can, because these data brokers don't particularly care who they sell the data to, they just want the money, it's a problem. So obviously they take care of you with data brokers, but they also have transaction monitoring, spam and junk email removal. They have an antivirus and a VPN. One of the things I've benefited from is their spam call protection. I used to get spammed like crazy not only on my business numbers, but on my personal numbers. I might get one a day now. It's very rare. It is just wonderful, all of the different things they can do. They're a one-stop shop when it comes to protecting yourself online. And we watch enough court to know how bad people can abuse things. So go to aura.com/TCF. You can scan the QR code on the screen. There's a link in the description. You can type it out yourself, whatever you need to do. But go there, sign up in the first 14 days. It's free. You'll find out within the first 24 to 48 hours where all of your data is, and they will start working on removing it for you during that 2-week free trial. So you have nothing to lose. And if you like them, stick with them. But give it a try. Aura.com/TCF. It's worth it. Trust me. I've been using them for months now, and it makes a huge difference. So give it a look. All right, let's go back to Judge DeSanto.
Sir, Judge. Thirdly, the police report says that the Riverview police arrested him in Southgate, not in a hot pursuit. I believe that would have been an unlawful arrest, and so he would be unlawfully detained at this moment. I would ask that he be put out on bond for that issue. To be brief, also, as I'm sure the court's aware, domestic violence is notoriously spotty when it's prosecuted by the police out of any charge. So even though my client is presumed innocent under the law anyways, specifically with a charge like that, he should be presumed innocent. But particularly concerning in this case is that the complaining victim was so drunk that night she couldn't make a police report. The next day, when she's interviewed by the police, she admits her memory may be affected by drinking in the police report in writing. She admits to hitting my client with a cord and punching him in the face.
Hold on, just one moment. I need the prosecutor in here, please. Hold on, is it?
What about the last day of Christmas? Right. Oh, this is not.
And counsel, your appearance, please.
Good morning, Your Honor. Mohammed on behalf of the people.
All right, thank you. And so Mr. Quartz has made a bond reduction request. Mr. Quartz, if you can start from the beginning again, just so Mr. Mohammed can hear all that.
So what's the applicant, Judge? I believe that my client, the Riverview police say in their own report that they detained and arrested my client at a settlement located in Southgate. I believe they actually put the word Southgate in their report. That's outside of their jurisdiction. It wasn't a hot pursuit case. He would have at that point been unlawfully detained without a warrant. He would then currently be unlawfully incarcerated. I would ask that at least while that issue is brief, any evidence that would follow from that investigation, I would then argue should be stricken. But while that issue is being briefed, I would ask that my client be relieved of a pending bond. Following that, according to the police report, she was so drunk she was unable to make a police report that night. That would, of course, go to her credibility. She admits the next day that her memory may be affected due to the drinking. She also admits in her police report that she hit my client with a sword and admits to punching him in the face. Now, one may presume that she was doing that in self-defense, but her quote is, she stated she punched the defendant in the face when he did not allow her to gather her additional items. That would indicate that my client was a victim of abuse that night. In fact, my client was making a police report with the Southgate police that night, which would give her a motive to lie and then press these charges. So for those reasons, I would ask that his bond be tethered. He has no history of failure to appear that I'm aware of. Plus, the danger to the community argument would be eliminated by tether. I'd also just like to quickly read in a one paragraph letter from his father.
No, no, I don't have that person here, so we're not going to allow that to be read right now. Do you have any further argument regarding bond counsel?
Gotcha.
Okay, Mr. Mohammed?
Judge, the people would object to modifying bond. I do believe it is appropriate. The defendant does pose a danger to the public. He has a previous conviction for operating while impaired, as well as a prior domestic violence charge. So based on that and the facts stated in the report, the people would object.
Counsel, who was the victim on the matter from Ypsilanti in 2016?
I believe that was another woman, Your Honor.
Not this individual?
That's my understanding. I don't want to misstate it before, but that is my understanding. I wasn't on the case.
Okay, Mr. Christmas, the conviction that you have for domestic violence in Ypsilanti in 2016, who was the victim?
Well, it was an ex-girlfriend that I don't speak to anymore that has tried to message me before about
Hold on,
contact her.
Sir, I don't need any extra. I just want to know who the person was. I don't need any backstory. I just need the person. It's not this current individual?
No.
What about 2017? You were charged in Riverview for domestic violence. Who was the alleged victim in that matter?
I was not charged in that matter, ma'am. That matter was dismissed because that person was found not credible.
Sir,
So I'm not
again,
understanding.
you're not following my instructions.
I'm just
My
not understanding. I'm
instructions
sorry.
were, who was the named alleged victim in that matter?
Her name was Haley.
Okay, so not this individual. 2021, there was an assault and battery out of Wyandotte. Who was the alleged victim in that matter?
I'm not sure, man. I was not convicted of that. I'm not really understanding.
Sir, I'm aware you weren't convicted. I'm asking who the individual was.
The alleged victim was a gentleman.
That was my question. And then I believe there was also a time that you were before this court and your grandmother was involved somewhere, correct?
The review was trying to get my grandmother to say something, but she
Sir,
came in, man.
Sir, excuse me, yes or no, is that correct?
I'm just not understanding your questioning for this, man. I'm sorry.
There is also another matter that your grandmother was a named complaining witness or victim, correct?
Allegedly, man, but she came into your
So
court.
yes or no? That's all I need, sir. Yes or no?
I would say no. She came to your court.
So, counsel, the court asked because there was something that involved your client's grandmother as an alleged victim, and I don't recall if that was assaultive or if that was a malicious destruction of property. I do not recall that off the top of my head, but I do recall that she was present.
But if I said, I'm not sure because I wasn't there, but my understanding is, and the family is in court, that the grandma came and said that that wasn't the case of the court, but I wasn't here. So it's my understanding, per the report of the family, the grandma is in support of his release.
Is the grandmother here?
She's not here, but the mother and sister are, and I spoke personally to his father, who is a retired Detroit police officer who was paralyzed, who's not in duty, and he's told me that he will ensure his son goes up to every court hearing.
Well, here's the concern of the court. Number one, your client is currently on probation here in this court. Secondly, this court is very familiar with your client, given the number of times that he's been charged in this matter with assaultive crimes. He has a prior domestic violence charge. And now here we are in this matter where your client is charged with assault with intent to do great bodily harm less than murder and domestic violence second offense notice. The court would also disagree that a tether would ensure the safety of the community, because that just means that we can locate your client if we need to locate him. That doesn't, a tether doesn't do anything regarding your client's potential actions or inactions or otherwise. So based upon all of those reasons, the court's going to continue bond and conditions as it is currently ordered. The court finds your client is a danger to the community and is going to continue the bond and conditions.
Judge, and would the court be inclined to refer it out for a bond recommendation report?
For DSU, I can certainly do that, but I can tell you all the times I've referred it, I don't ever get anything back from them here at this court, but I will certainly refer.
Thank you.
You're welcome. All right, we'll see everybody back next week on October 9th, and you witness and exhibit list by October 6th.
Yes, Judge, thank you.
Thank you. Have a good day. We are on the record in the matter of the City of Wyandotte for Shannon Pichet, 251419A. B and C. Mr. Golpa? We don't have Mr. Golpa. Just one moment. Okay, thank you. Oh, there he is. Okay. All right. And counsel, I'm calling okay. He's just grabbing his notes. It'll be just one moment. Who's Kim Gardner here on? Kim, oh, there she is, 10:30. Right, and counsel?
You're on the John Gold, please, 30758, I'll be there. There's Piche.
Yes, I'm not sure if it's Pichet or Piche, but we'll find out in just one moment. Ma'am, your name for the record, please.
Shannon Pichet.
Okay.
Your Piche is charged with offering while intoxicated, possession of drug paraphernalia and open intoxicants. Dr. Ms. Piche, at this point in time, she would waive a full reading of the charges, ask the plea of not guilty. Stand mute, ask the plea not guilty.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, schedule this matter for pretrial October 15th at 8:45 a.m. And counsel as to bond.
As to bond, Your Honor, Ms. Shea is 35 years old. She's single. She is gainfully employed as a housekeeping for Corwell Health in Trenton. She has no prior criminal record. She's never failed to appear for any court appearances. As far as I can see in check, we're asking for personal in this particular matter. If that indicates she's gainfully employed, nothing. She's a lifelong resident of the city. The personal bond in this particular matter would be sufficient to make sure she appears.
All right, ma'am, who lives at the home with you?
I'm sorry?
Ma'am,
Oh, my mom and my dad.
all right. Have you ever failed to appear in court for any reason?
Oh,
Are you out on bond in any other jurisdiction?
no.
If you were to test right now, what is in your system?
Alcohol and cocaine.
Given the nature of the charges, and the concern this court has for the safety of both Ms. Bichet and the community, the court's going to order a $5,000 10% bond. In the event bond is posted, you are to report to probation, ma'am, to set up scheduled or random testing, not to possess or consume any alcohol or drugs unless prescribed. Thank you.
Thank you.
Sorry, I'm sorry, that's to count A. Count B and C will be 5,000 personal.
Thank you very much, Ron.
Thanks, Ally.
Okay, Mr. Shea. We'll see you in a couple of weeks. Make sure you're here in court. Thank you, Ron.
All right, and then we're going to call the matter of Robert Allen. In just one moment here, let's go off the record for a moment. Mr. Gopal, do you speak to me?
All right, well, she goes off record. Let's go back to Judge Boyd.
Bravo, can I have parties announced?
Daniel Cranbrook for the defense.
And are you Dora Marie Bravo?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? You're gonna need to speak up.
Yes, ma'am.
Are you the same Dora Marie Bravo who was placed on deferred adjudication in 2024 CR 011954 for the offense of possession of a controlled substance, penalty group 2, less than 1 gram, on June 3rd, 2025 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Filing condition number 14AA, on or about the 11th day of August 2025 in Bexar County, Texas, the defendant Dora Marie Bravo did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department, in that the defendant failed to follow top recommendations for SATIF in violation of condition number 14A.
How do you plead to that? True or not true? Did you understand by pleading true to violation 14AA, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of 14AA?
Yes, ma'am.
Court will find 14AA true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion, enter an adjudication of guilt and sentence to 126 days in the state jail facility under 1244A.
Would it be in the Bexar County Jail?
Yes, state jail facility, Bexar County Jail.
Those
No.
are.
I'm
Oh,
sorry.
just 1 second.
Bexar County Jail, Your Honor.
No problem.
Apologies.
No problem. All right, here's my question. What has she done on probation?
She never came out of custody, Your Honor. So she took the plea back in June, and they recommended SATIF, which she didn't agree to.
Okay.
So she's been in custody for the whole time.
All right, so I'm not gonna follow this agreement. There are rules and regulations that you have to follow for probation. Otherwise, you're not on probation. You're just doing your thing and telling people what you would not do. Your conditions of probation were parenting classes, which tells me.
I signed up for parenting while I'm in.
No. So here's the thing. You were supposed to be going to SATIF because obviously you have a drug or alcohol problem. If you did not, they would not have recommended that. So I'm sorry, what?
It wasn't on the paperwork that it was given to me.
No, they told you that you're supposed to be going to SATIF
She's saying for your evaluation, not for your original plea.
because according to the conditions that I gave you, I said that you are not to have any contact with Roberto Avalos, JCPenney stores, and that you're to complete the TAP evaluation while in custody, follow TAP recommendations. There was a referral to felony drug court, and you decided you don't want to do that, and now you feel as though you're entitled to an agreement where you just do Bexar County jail time. It's not going to happen because you didn't follow the conditions that the court set for you.
If I may, Your Honor?
Yes.
She doesn't have any felony convictions at this time. She was willing to take the conviction in order to not waste anybody's time. She just doesn't think so that she'll be successful on the probation, and so she's asking for the full plea.
All right. Well, what I can tell you, part of my issue is, well, not issues, part of my duties is to protecting the community. And for me to say that you were to do parenting classes, that means that you have a child. Otherwise, I wouldn't have recommended parenting classes.
She doesn't have custody of him at this time.
Yeah, see, that's the problem, the at this time part, that's the problem. So what would end up happening is you would go to jail, you would do your 124 days or whatever it is. The jail would give you 3 for 1, and you probably have a judgment satisfied, or they give you 2 for 1. You probably have a judgment satisfied. You would walk out, go do your drugs or whatever, and then go pick up your child from wherever he is. So these are your 2 choices, and these are your only choices. Either you're going into inpatient treatment, or either you're getting 2 years at the state jail facility. Which do you prefer? All right, so the court will deny the motion, alter and amend conditions to include SATF, and upon release from SATF, there's to be no unsupervised contact with or residing with minors. And that will be revisited once she completes her parenting classes. In probation, was she not eligible for felony drug court?
That she was not. Oh, let me just double check. Did not meet criteria, Judge.
All right. All right, is there anything else you need from the court? All right, thank you. Thank you.
Thank you, Judge.
All right, let's change it up and go to the Commonwealth of Kentucky. Judge David Williams, spend a little time there.
Díaz Escalona.
Usted es el señor Díaz Escalona.
Sí. You born
Yes.
You were born in 1997.
Naciste en el año 1997.
Sí.
Yes.
Last 40.
2951 es los 4 últimos dígitos de tu seguridad social.
We're on 25 CR 0026.
Estamos aquí con el caso número 25 CR 0026.
For a pretrial conference and motion to revoke bond.
Estamos aquí para una audiencia previa y para una moción para retirarle la fianza.
Mr. Stockton, what do you have here?
Well, we may need to have some filings with the clerk. We've got a plea, a felony plea on 25 CR 26. Then we've done an information indictment. We need a number on a possession of meth case. Has it been filed?
25 CR 61. I don't have paperwork.
Okay, I think Mr.
25 CR what?
61.
00061.
Parece que tenemos una declaración pendiente para el caso que acaba en 26 y luego estamos pendientes de una cantidad de metanfetamina para el caso que acaba en 16.
You have a plea agreement with him. Just hold it there and I'll ask him that way. He'll identify his signature. I'll just go down through the situation.
And I misspoke. It is a diversion agreement rather than a felony plea.
Y voy a corregirme porque esto es un acuerdo para un programa alternativo, no para declaración de delito mayor.
A motion has been tendered that says you wish to enter a guilty plea to that today. Is that correct?
Se ha presentado una moción indicando que usted se quiere declarar culpable hoy para dejar el caso resuelto, ¿cierto?
Are you currently under the influence of drugs or alcohol?
¿Actualmente está usted bajo el efecto del alcohol o de alguna droga?
No. Is this
No.
plea freely and voluntarily given?
¿Está usted aquí de forma libre, consciente y de forma voluntaria?
Sí, correcto.
Yes, correct.
Are you the same person named in indictment number 25 CR 0026?
Su nombre es el que aparece en la imputación oficial de los cargos para el caso 25CR0026. Yes.
Is your judgment impaired today in any way?
Hoy tienes la mente turbia, estás incapacitado para pensar con claridad hoy.
No.
No.
Have you discussed these charges with your attorney and are you satisfied with his advice?
¿Ha tenido usted tiempo de hablar de su caso con su abogado y se siente satisfecho con el trabajo que ha hecho su abogado por usted?
Have you reviewed the evidence? Have you reviewed the evidence the Commonwealth has against you?
¿Ha revisado usted las pruebas que tenía la fiscalía contra usted?
Do you believe you're fully informed about your case?
Entonces usted siente que tiene toda la información necesaria acerca de su caso.
You understand that you do not have to plead guilty today.
Entiende que usted no está obligado a declararse culpable hoy.
You have certain rights under the Kentucky and United States Constitution.
Tiene derechos constitucionales según las leyes de este estado y del país.
Before I can accept a guilty plea today, I need to know that you fully understand those rights.
Tengo que asegurarme que usted entiende los derechos que tiene antes de aceptar su declaración.
You have the right not to testify against yourself. No one can make you say anything.
Tiene el derecho a no declarar en contra de usted mismo. Nadie le puede obligar a hablar.
You have a right to a speedy trial by jury.
Tiene derecho a un juicio con celebración, con juez o con jurado.
You have the right to be represented by counsel at your jury trial.
Derecho a tener abogado que le represente durante el juicio.
You have a right to confront and cross-examine all witnesses called to testify against you.
Derecho a interrogar y contrainterrogar a los testigos que declaren en su contra.
You have a right to produce evidence.
Derecho a traer pruebas.
To call witnesses in your favor.
Y a traer testigos que declaren a su favor.
To appeal this matter to a higher court if you lose.
Derecho a apelar cualquier sentencia a un tribunal superior.
And to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you.
Y derecho a que sea la Fiscalía quien tenga la carga de prueba de demostrar su culpabilidad más allá de cualquier duda razonable.
You understand about entering a guilty plea today, you give all those rights.
Como usted se va a declarar culpable hoy, entiende que no habrá juicio, por lo tanto, renuncia a sus derechos asociados a un juicio. ¿Sí o no?
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law.
Puedo aceptar la recomendación de la Fiscalía, pero también tengo derecho y autoridad de sentenciarlo conforme a las pautas que indica la ley.
Prior to accepting any recommendation, I will review the pre-sentence investigation report. Now, this is a pretrial diversion on one of them, but on the other one.
Well, that's since they're being done contemporaneously. However the court wants to handle it.
Yeah, before I go any further with this seems rather unusual to me. This gentleman was in court here previously.
Yes, what happened was he was charged with having a vehicle with altered VIN number.
Yeah.
When he left court, he was picked up on possession of methamphetamine.
And he had a bad license plate too, didn't he?
I don't know. I'd have to look at that. Yeah, he had a altered registration, no registration plates.
Altered.
Yeah, revoked license. He's gonna have to get his act together if he's gonna complete his diversion or felony plea.
You know, it just, I don't know the facts of the case other than what I read there. It just seems a little odd to me that we got him on a VIN thing. Was arrested on a VIN thing originally. Then he comes back down here with a vehicle with the altered. Was that a stolen car that he was down here with that had the bad plate on it? He comes down here with a stolen car and meth?
Let me see. I'm looking for the new paperwork on the information in that. Now, all this put together, my understanding was on all the illegal traffic violations was on the first truck when he came down here, what he was indicted on initially. When he left, that's when they got him on the possession of meth. You got that name?
El primer caso que tienes por haber tenido un vehículo en venta con un número de registro alterado. Y el segundo cargo es por haber estado parado por posesión de metanfetamina.
Here, I found it, Your Honor. On the information indictment, he had no registration plates. and an altered registration plate, what he was charged with. And possession of a controlled substance, third degree and first degree.
Whose car was it? Let her interpret here. Go ahead.
El primer cargo que tenía era por cosas de tránsito referentes a la matrícula y al número de registro del vehículo. Y el segundo cargo era por la metanfetamina. El juez pregunta, ¿de quién era el vehículo?
If I may offer, Judge,
Do you speak Spanish?
no, sir.
How were you communicating with him back there then?
I have a translation app. He speaks some English, Judge.
Yeah, okay.
I also have a translate app.
Okay.
We're able to communicate.
I didn't know whether you get in here with your phone or not, so. Go ahead. You can go ahead and speak, defense counsel.
The felony on the information is the possession of the controlled substance. I think the altered plate was just a violation. So the new felony is actually having the controlled substances as a further punitive measure as part of this.
You'll let the interpreter.
Yes, sir.
El delito mayor que tiene es solamente por la posesión de metanfetamina. Los cargos que tiene de matrícula y del registro de vehículos son solamente infracciones de tráfico.
As a further punitive measure, if you will, and as part of this negotiated settlement, he is forfeiting both vehicles.
Well, that's almost correct. The first vehicle, the truck that had the altered VIN number in, he's forfeited. The second vehicle, which he was arrested in when he left court, that didn't have registration plates, it had a title to it, and Sheriff Williams released that to the owner.
Okay, I did not realize that, Judge.
Yeah, it was titled correctly, it wasn't registered.
De los dos vehículos que tiene, él va a hacer entrega de los vehículos y el fiscal corrige que el primer vehículo, que era una camioneta, sí que hará entrega de ella y el otro lo llevaron a la persona a la cual está registrado el vehículo.
And he has no prior felonies, Judge.
Y no tiene ningún anterior condena de delito mayor.
Wonder who the owner of the vehicle was.
It's not in the police report, I don't know.
¿De quién era el propietario del vehículo?
I'll look again, make sure I don't need to look at. No, it doesn't say who the owner was.
Have you previously been diverted in the last 5 years?
Caballero, en los últimos 5 años, ¿ha estado usted en el programa alternativo?
I'll say this.
I don't know what that is.
Have you had a pretrial diversion? Have you been in court and entered into a pretrial diversion that you're entering into today?
Es decir, en los últimos 5 años, ¿ha tenido usted algún caso en el tribunal y en lugar de condenarlo o multarlo, le han permitido que hiciera unas clases o programa?
You have any felonies in the past 10 years?
¿No tiene condena por ningún delito mayor en los últimos 10 años tampoco?
You understand that if you fully complete the diversion agreement, the charges will be dismissed.
Entiendes que si cumples todos los términos y condiciones del programa, tus cargos serán retirados y perdonados.
You understand if you do not successfully complete the diversion program, you'll be brought back in front of this court and your pretrial diversion will be revoked and a scheduled sentencing hearing will take place.
Y de lo contrario, si no completa usted el programa con éxito, volverá a estar aquí frente a mí y se le condenará a un plazo de tiempo de cárcel.
What is the Commonwealth's recommendation?
Upon a plea of guilty to selling a vehicle with an altered VIN number.
La Fiscalía sugiere que se declare culpable a un cargo único de haber vendido un vehículo con un número de registro alterado.
The defendant shall receive a sentence of 3 years.
3 años de condena.
upon a plea of guilty to possession of a controlled substance, first degree.
Declararse culpable a estar en posesión de una sustancia controlada,
In case number 25 CR 61.
que ese es el número de caso que acaba en 61.
The defendant shall receive a sentence of 3 years.
También una condena de cárcel de 3 años.
The two sentences shall run consecutively for a total of 6 years.
En caso de cumplir condena, se cumplirían 3 años más 3, por un total de 6.
He shall serve 45 days.
Tendrá que cumplir tan solo 45 días de cárcel.
The pretrial diversion shall be for a period of 5 years.
Y después tendrá 5 años de plazo en libertad, tiempo durante el cual tiene que hacer el programa alternativo.
The diversion is to be supervised by probation and parole.
Y el programa será supervisado por el Departamento de Libertad Condicional.
He shall be released from custody on October 12, 2025.
Y este día 12 de octubre de este año 2025 será puesto en libertad.
He shall receive credit for time served.
Por lo tanto, se le van a restar los días que ya ha estado en la cárcel a los 45 días y su salida será el 12 de octubre.
The Ford 2012 F-350
La camioneta del 2012 F-350
shall be forfeited to the Cumberland County Sheriff's Department.
será entregada al departamento del sheriff del condado.
He agrees to be assessed by the Social Services Commission.
Y también se someterá a una valoración por parte de servicios sociales.
And shall follow all recommendations.
Y tendrá que seguir todas las recomendaciones de ese departamento.
He shall pay court costs at discretion of the court.
Y tendrá que pagar costas judiciales si su señoría lo considera oportuno.
All drugs and contraband shall be destroyed.
Y cualquier tipo de droga o contrabando que se incautara para este caso será destruido.
Is that your understanding of the Commonwealth's recommendation?
¿Está usted al tanto de la recomendación del condado?
Yeah.
Yes.
Has anyone, including your attorney, offered you any other benefit for entering this plea?
¿Alguna persona le ha intentado convencer de alguna manera o prometido con algo diferente? No.
You are pleading guilty to the acts that you committed in both these charges, the indictment and the information, because you did those acts. Is that correct?
Se está declarando usted culpable de estos dos cargos porque en efecto usted cometió estos dos actos, ¿correcto?
Knowing your constitutional rights, have explained to you, is it still your desire to proceed with the plea and allow the court to fix your punishment in the range permitted by law?
Después de considerar todo lo que he leído explicando, ¿está usted dispuesto a seguir con su declaración de culpable y dejando en mis manos la condena según las pautas de la ley?
Is that
Yes.
your signature on the motion and offer?
¿La firma que está ahí a pie de página es suya? Yes.
Mr. Stockman, what kind, before I accept the agreement diversion, or what kind of background check did y'all do on this?
We did a Kentucky CourtNet search, and we also did an NCIC report. He had some felonies in Jefferson County that have been amended down, and they involve stolen property. So I don't know if he's involved in a car theft ring in Jefferson County. I don't know why he was down here in Burkesville, but he's got 6 years hanging over his head, and he's gonna be on probation, so he better be living at the cross, because I will file a motion to revoke him, because I don't know what his status is, why he was here, and what he's been doing.
Hemos visto que sí que tiene algunos antecedentes en otros condados, pero no sé cuál es su estatus inmigratorio en este momento aquí.
I will accept the agreement and sign the diversion order.
Acepto el acuerdo y firmaré la orden para el programa alternativo.
That's your signature on there, sir, did you say?
Esa firma es la suya, ¿verdad, caballero?
Now, you need to wait till after your interpreter tells you what I say before you answer it, because I know you can understand everything I'm saying.
Espérese a que la intérprete traduzca antes de contestar, porque yo entiendo que usted comprende lo que estoy diciendo.
Okay, you need to meet with the probation and parole officer. I don't know how we're gonna do this exactly. He's gonna be in jail up there for a few more days. Can you see him up there with the interpreter online or something?
Se va a reunir con el agente de libertad condicional en la cárcel porque va a estar unos poquitos días más en la cárcel.
The police said he's supposed to get out on the 12th, which is Sunday. if he could report to my office on the 13th, I can facilitate his transfer back to, I think he lives in Louisville. I'll have to do that.
Okay, you give his attorney the address, of the probation parole officer, you'd be there at 8 o'clock.
8 a.m. Your Honor.
8 a.m. on the 13th, which is the day after you get out, okay?
Caballero, usted saldrá de la cárcel el día 12. El día 13 a las 8 de la mañana tiene que reunirse con su agente de régimen probatorio.
Court cost is $190. You need some time to pay that?
Debe $190 de costas. ¿Y cuánto tiempo necesita para pagarlo?
Judge, if we could get maybe days or something of that nature, 90 days.
Well, I'm only
90
paying
días.
30 days. I'll let him pay it at $50 a month, first payment.
You'll get it paid.
Do it in 30 days. Yeah, I'd say his employer wants to get him paid, probably.
Thanks, the judge. He told me his wife's present. She can pay it today if you'd like.
That's good.
Lo tiene que
Okay.
pagar a razón de $50 al día hasta que esté al mes hasta que esté pagado los 190.
Okay, thank you.
Thank you, Judge.
Muchas gracias. Thank you, everybody.
You are released, Madam Interpreter. Thank you.
Barbara, thank you for gifting the membership. I appreciate it. Let's go back to Judge DeSanto.
Good morning again, Your Honor. Robert Goldman, P. 1222, here on behalf of the Wasatch and Robert Allen, present in the courtroom this morning. Mr. Allen, would you please state your full name for the record? Robert James Allen.
Okay, and so counsel, you did approach the bench earlier to confirm one of the stated convictions that was showing for your client on the second amended pre-sentence report and recommendation. And then I did step off and spoke to Ms. Shaw, and that she then did confirm again, as somehow there was a misreading somewhere, that it was in fact dismissed.
Yes.
So now you did receive a copy of the third amended report, correct?
Correct, Your Honor.
Okay. Counsel, before we go into allocution or otherwise, Mr. Allen, let me state this, okay? That I understand that sometimes your emotions get the better of you, but my staff is not at all going to be somebody's verbal punching bag. It's my understanding that you were yelling and screaming so loudly at Ms. Shaw that she ended up hanging up on you, which she has this court's full support on. My staff is not to be verbally abused or assaulted. Is that clear? Thank you. Counsel, you may proceed. Did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. And thanks to the court, your staff, and the probation department for the accommodation in verifying that one piece of information that we would discuss at the bench bar. Fortunately, in light of that accommodation, there are no further additions, deletions, or corrections to be made. We are prepared to proceed with sentencing, having received and reviewed in full the third amended PSI report.
Okay, and counsel, as to the recommendation.
Thank you, Your Honor. With respect to the report, rationale, recommendation, and given my time here working with Mr. Allen, as the court is aware, this matter, we've been before you several times over the last handful of months. And I think that actually provided a great benefit to me in allowing me to work even closer with Mr. Allen, to understand him even deeper for purposes of today's sentencing. Your Honor, with respect to Mr. Allen, one of the things that I'm certainly very encouraged by is the relationships that he does maintain with his family, namely that being with his siblings, with his children, with his stepfather. Mr. Allen, while going through the day-to-day trials and tribulations given his physical condition.
Hold on one second. Counsel, just so you're aware, we can hear what you're saying in the microphone, and that's pulling from here. Okay, thank you.
Your Honor, as I was saying, and it's noted within this, the probation department's report, Mr. Allen has experienced a number of very significant injuries that have left him in a disabled condition, which he is unable to work in a full-time 9-to-5 sense of things, given, as I mentioned, the really significant injuries that he's maintained and really, tried to overcome over the last decade or so. But with respect to that, Your Honor, with respect to the time that he has, he certainly uses that to the most productive efforts with respect to taking care of his family. He is He provides a great caretaking service for his stepfather, particularly after the loss of his mother. He's a great father. He was just telling me about the overnight he got to have with his son due to a need for his son's mother couldn't care for her son last night. And we've oftentimes really spoke about the relationship that he has with his children, especially his youngest children now. And it's one of the most important things to him. And so I think he looks as a silver lining of his disabilities that gives him more time to be involved with his closest relationships. They not only provide a great productive use of his time, but they do certainly provide a great support system for him. They have been a great support system prior to this matter, and certainly he is certainly remorseful and regretful, and certainly is taking on efforts to address that, to be a more productive, responsible citizen member of the communities. Because that's all he does really want moving forward, Your Honor. He wants to understand that he did wrong, that he can make amends for that, and then go forward and live a productive, meaningful, and perhaps most significantly, quiet life. He wants to be able to take care of himself, his children, and his family at large. He wants to be a productive member of this community and any community that he may be in. And I do believe that with the deep understanding both of these proceedings as well as himself, he is capable moving forward in a very healthy, productive manner. I do think it is noteworthy if you do look at a prior record. His last offense of any kind was in 2013 for a driving while license suspended. He has not had any contact with the criminal justice system in the time since then for this matter. Or I'm sorry, Your Honor. He did have contact with the criminal justice system. Ultimately, that was a case that was dismissed. I should more clearly say he has not been convicted of any offense since 2013. If you further look at the record, his record does not have anything violent or assaultive. His record does not have anything substance related. His background is not one that contains history of substance abuse, substance use. And as we talked about his use of alcohol in the past, he has advised me that he does not really like to drink. When he does drink, it typically, as was in the case of this incident, occurred during a Lions game where he was watching with his son. And unfortunately, he now recognizes that there is a very necessary cutoff. People can enjoy the sporting event. Many people might like to partake with a beer or otherwise while enjoying that sporting event, but he understands even more clearly now that there are limits and we need to adhere to those limits so that we can be that productive, responsible member of the community. He's taken that lesson and every lesson gained through these proceedings, and he will channel that going forward to make sure if he ever wants to enjoy a Lions game like that again, that there's absolutely no use of an automobile at any time thereafter. His history does not provide one which shows a alcohol abuse problem. And I do believe that the difficult, challenging process of resolving this matter reinforced a very important lesson regarding responsible consumption. Your Honor, he is properly licensed with a medical marijuana card because that has been his primary form of treatment for the physical limitations or disabilities that he has had. He does not have a history of abusing or otherwise violating the law with respect to marijuana, and I believe has shown that he is capable of being a responsible user in that sense. But with respect to Mr. Allen moving forward, as I noted, he just wants to go forward, put this behind him, not because it doesn't matter or it's insignificant, but put this behind him so that he can be that best father to his young children, that he could be the best brother to his siblings, and the best stepson to his stepfather, especially at a very difficult time, having lost his mother and his stepfather's wife. With respect to moving forward, Your Honor, the probation department is recommending a sentence, fines and costs and alcohol tethers. I believe that that is an appropriate recommendation with respect to fines and costs, particularly in light of MCL 769.5. With respect to the alcohol tether, Your Honor, I'm not sure that that is necessary at this time. The reason I would say that is through the course of these proceedings, Mr. Allen has not violated the bond with respect to alcohol. Mr. Allen has not engaged in any new criminal behavior involving alcohol or otherwise for that matter. And I'm not sure that an alcohol tether will necessarily provide a rehabilitative benefit consistent with sentencing guidelines in the state, but rather it would impose an additional financial constraint that I don't believe is tailored to a productive goal of sentencing. With all due respect, Your Honor, I would ask that the court follow the recommendation with respect to fines and costs. I would ask that the court consider not ordering the alcohol tether, given that there has not been an alcohol issue since Mr. Allen was first arraigned in this matter.
All right, thank you. When did your client obtain his medical marijuana card?
Your Honor, the card was issued on May 7th, 2025. However, I do know from speaking with Mr. Allen that the process was engaged in advance of the date of issuance because, as I believe we know, you have to go through doctors, submit the materials before it is issued. So I do know that he did generate those efforts prior to that issue date. And I would just further note, Your Honor, Mr. Allen did previously have a medical marijuana card. He had maintained one of the cards he had been issued previously. This was a card that was issued in 2012. This particular card expired in 2013, but Mr. Allen had advised me that he had continued to receive these cards up until the time that recreational marijuana was legalized in the state. And at that point, the cost of the medical marijuana card was outweighed by the ability to actually to obtain by way of the recreational legalization. And so when this matter arose, he did initiate those efforts to be properly licensed.
Okay, so let me ask a few questions. Did you receive that medical marijuana card as a recommendation from your treating physician?
No.
No. Do you have a treating physician?
No.
So you have continued medical problems for which you need marijuana for medication, correct?
Yes.
But you don't have a treating physician to treat you for those continuing medical problems.
No, because when you go to the doctors, all they try to do is give you pills for your pain. And I don't want to be addicted to pills.
Sir,
Well,
as the patient, you definitely have a right to engage in conversation with your treating physician as to the best course of medication treatment for you.
yeah.
The concern this court has is that you have alleged that there is a number of medical conditions by which you need marijuana. But this court is very much aware that when an individual walks into a medical marijuana clinic to obtain medical marijuana card, there isn't any follow-up to confirm that that medication is in fact working as it should, such as somebody with high blood pressure has follow-up appointments with their doctor to make sure the medication is working. Somebody with high cholesterol or sugar issues. So if the marijuana is for true medicinal purposes, then there should be requirements and, I'm sorry, not requirements, but follow-up appointments that are already scheduled and that you see on a regular basis to ensure the medication as prescribed is working for you. That is this court's requirement as it relates to marijuana for medical purposes, which I know I've stated to you before. And so you have this medical marijuana card that you obtained while on bond and under jurisdiction of this court without having anything from your treating physician. And further, just so you're aware, all I would need from your treating physician is some communication that that's the preferred method of medication, and you wouldn't have to even go through the steps of the medical marijuana card. And I know I've stated that to you before as well. Which apparently is where things went awry with the conversation with Ms. Shaw. Council, after review of the report and recommendation, hearing from council, hearing from Mr. Allen, the court agreed that there is not reasonable grounds to depart from MCL 769.5. The court, in further review of the report regarding the report of substance abuse assessment, shows your client is a category 3 alcohol and 4 drug user. Presumably, the category 4 is based upon your client's marijuana use. Based upon that, the court does find that the recommendation is appropriate. The court's going to order 60 days on the alcohol tether. So what I'm going to do is I'm going to have you, I believe that the Wayne County Jail, I guess it depends on who answers the phone when, or responds to the email. You can go to Wayne County Jail for that. Not in custody. You just go down to the Wayne County Jail and then they can affix you with an alcohol tether. That's much more cost effective than an independent third party. The court's going to also order a $300 fine, $100 screening assessment fee, $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $825. And sir, do you have any, I think you posted a bond. You did post a bond.
Yes, Your Honor, I was just gonna ask if we could confirm with Mr. $500 bond, if that could be applied to the fines and costs in this matter.
You did.
Mr. Allen just indicated to me that you could pay the balance.
Yes.
You have $325 to pay today. Okay. Then yes, so then I will indicate that's payable today. All right, so you're going to go over to probation. And they are going to give you the information regarding going to obtain the alcohol tether.
Okay,
Okay?
yes.
I strongly, strongly hope that you've heeded what I've stated earlier and that you've listened to your attorney with his excellent representation of you, sir, in what he stated that you've taken away from all of this. So, and I'm hoping that you are not going to verbally assault my staff as you are going back there to get information regarding your alcohol tether. Okay? Thank you. Have a good day. Good luck to you. We are on the record in the matter of the state of Michigan versus Henry Hearns, 251161.
You're might be a coach or a conference in the chambers about the kids.
Yes, we can do that.
Okay, thank you.
All right. I just need Mr. Who?
Good morning, Your Honor. Stephen, can you have
Okay. All right. I saw your name earlier on something. So, okay, let's go off the record.
All right. Well, she goes and takes care of that. Let's go back to Judge Williams in Kentucky.
Your Honor, Ms. Stotts has a 5-year sentence on false statements to receive benefits. She's paid the restitution in full on that case. Yes, but I think it's about a year and a half ago. And this is a motion because she's tested positive again for marijuana on 9/2/25.
Response, Your Honor, Ms. Stott says it's Delta 8, Delta 9, and Ms. Stotts indicates that what she purchased was purchased over the counter. To simplify things, she has decided just to cease and terminate use of any product whatsoever regarding Delta 8 or Delta 9
And I think it would be appropriate just to put her on unsupervised probation at some point in time. So she's got everything she.
Have you got, I got the report. Where's that report? I guess it's in here, baby. Could you help me find that violation?
We had a problem once before and she had gone out of state to purchase some items and she got some sanctions on, how long did you stay in jail then?
3 weekends.
Yeah, 3 weekends.
I watched the tape. She'll find it. I want you.
We'll have a chat.
I mean, she's got numerous violations.
Yeah, it was
I
all,
don't understand why I haven't revoked her already, you know.
all those looks like we brought it to the court's attention back in 2024. That was when all this came to a head and that's when you gave her the sanction.
Yeah,
And
I
then
watched that tape though.
Yeah, and then she had an additional violation in this August. So it's been, what, a year ago?
And as I say, we don't agree it's a violation because it's over the counter legal in Kentucky.
She says.
That's right. And that's.
She says,
Yeah.
I don't know that, you know, she had receipts where she bought it.
You wouldn't have a receipt. No, she has no
Well,
receipt.
she didn't buy it over the, you know.
She has her original certificate where she's permitted to obtain marijuana legally in the state of Kentucky. She does have that.
And I don't know, I looked at that a while ago.
Well, it appears to me, it doesn't really matter to me whether she can get it illegally or not. And here, Mr. Stockton, here's the way I look at this thing. Just so we all, since this is kind of the first impression, she can buy alcohol illegally too. But she's not supposed to use alcohol when she's on probation. Is that right? Can she use alcohol?
No.
Well, so what's the difference?
May I agree with that?
When I'm finished, you can. I'll give you your time. So I'm not gonna, I just don't want to go down this route from here on out, that anybody thinks they've got a certificate where they can legally use marijuana. I don't think there's any difference in that. They can legally use alcohol. They're not supposed to use it. Okay, and if they've got some kind of extenuating circumstances, they can notify the Commonwealth Attorney's Office and we can have a hearing of it. Now you can.
Your Honor, the difference is the prescription. You don't get a prescription for alcohol. You get a valid prescription from the Commonwealth of Kentucky for marijuana. I'm not saying I agree with the way the system is set up, and I realize there's tremendous gray areas in all this right now, but that is the inherent difference is the prescription. Somebody that comes in with a valid prescription, we got to look at it different, and this is going to be an ongoing problem, I know.
Where's her prescription? You have a copy of her prescription with it?
Okay. Yeah, perfect. Here we go.
Have you seen this?
I've got the certificate. Is that what you're referring to? Yeah.
Make a copy of this here. I'm gonna pass over this case until October the 23rd, and I'll give you a copy of this.
I've got a copy.
Okay, I want an investigation done on the validity of that prescription by the Kentucky State Police or probation and parole. See what's going on here. So you'll be back here on October the 23rd.
Thank you.
All right, let's head back over to Judge McNally.
Mr. Morales, your name? You have to unmute there, sir.
Get the deputy.
I got it. Okay.
Your name?
The host. Am I unmuted now?
I need your full name.
Edward Dante Morales, Your Honor.
All right, you're going to plead guilty, this says, to the charge of resisting obstructing an officer on file 5822 on the basis that you gave a false name. True?
Yes, Your Honor.
That is a
Yes, sir.
misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
Again, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to trial by court or jury. You have the right at a trial to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not gonna have a trial of any kind. You understand that?
Yes, Your Honor.
All right. To the charge, resisting obstructing an officer, how do you plead?
I plead guilty, Your Honor.
I can't hear you, sir.
I gave my false name because at the time, Your Honor,
Sir,
I plead guilty, Your Honor.
listen to me. Do you plead guilty or not guilty?
I pled not guilty, Your Honor. I mean, no, I'm sorry. I pled guilty, Your Honor. I can't, it's kind of hard to,
I'm going to ask you again. To the charge of resisting obstructing officer, how do you plead?
Guilty, Your Honor.
Were you in Flat Rock at 26813 Telegraph on May 21 of 21?
Yes, Your Honor.
Did you give the police a name other than your own name of Edward Dante Morales?
Yes, Your Honor.
And did you give them a different date of birth?
Yes, Your Honor.
Are you on probation or parole?
Right now, I'm on parole, Your Honor, but I'm almost off.
Were you on parole on May 21 of 21?
Yes, I was, Your Honor.
You understand by pleading guilty to this charge, this would be deemed a violation of that probation or parole? It could be revoked. Listen to me, please.
Yes,
It
Your
could
Honor.
be revoked and you could be incarcerated as a result of this plea and conviction. Do you understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Plea is accepted. Now, we have a sentencing.
No report.
I know. What is he in custody at?
Just, I'm looking at the register of actions. It looks like he got picked up. I think he was arraigned back in May of 21 on the initial concealed stolen property. And I think, I don't know how he got picked up, but I'm looking at the register of actions on the.
I know he's got these two. He's got 10,000, 10% on each one. I just want to know if he's got other holes.
I didn't inquire as to who sold.
Can you tell me, sir, are you in custody just on these two?
No, Your Honor, I got a charge that happened in August of 2022 that they just blew it up just now. So
Listen to what I'm asking you.
He's trying to develop credit, and that's where we've had some confusion.
Develop credit?
Time credit and being in.
I didn't ask you that.
No, that's not what I'm saying, Your Honor. I said I'm right now in custody for a charge that happened in August of 2022. Right now, it hasn't even been adjudicated. There's been not even a preliminary examination yet.
Oh,
so
all right.
And I was given a PR bond for this charge right here. And
which
and
charge? Which
the
charge?
I'm in here for, right? But I'm not the charge with you, but for the charge for which on this one here, which is a felony, I was given a PR bond.
All right, so you're just awaiting sentencing.
He hasn't been
For your case, I
adjudicated
am,
on the
Your Honor.
felony.
I got it.
And I think I saw PR in that one of those register of actions, but maybe that was historical. And then it compounded because he wasn't showing. He was arraigned on September 30th of.
Boy, you are really going out of your way to be unhappy here. You know that? Was there a police report in this file?
There was.
I'm talking about in the one for the concealing stolen property. He didn't.
I didn't see a report in the file for that. That's a 2020.
I know.
I didn't see a report. And you're just for edification, it was a sentencing today, so I didn't delve in too deep as to the facts of the case.
Well, I get it. I'd like to be able to sentence him, but I don't.
You don't have a screening and assessment.
I don't have a pre-sentence report. He didn't show up for that. The case been going on for 4 years. Yes, sir.
Your Honor, if I may, I know that when the case occurred, I was incarcerated. I got arrested, got incarcerated. I did time at the Wayne County Jail. I remember being released from there. I did like 4 months or more in there. My parole, that's why there's no parole hold on me for that charge right now. Because I've done time for the parole and for I had a piece of paper when I left the county jail. They gave me a piece of paper.
Slow down.
Okay.
You got a 4,010% bond that I set. I released you on December. I set a bond of 5,010% in December of 20. You were in custody for 5 days. You came back in front of me. I gave you a PR bond. On April 28 of 21, I set a 4,010% bond when you had a warrant out and came in front of me. 7 days later, I gave you a PR bond. And then you just didn't bother showing up.
I think Your Honor, it's not that. Please, I know it's so hard to believe, but please understand, it's not disrespect to this court. That's not what it's about. I know I was locked up for a long time because the girl that was with me when I got arrested.
Not on this case.
No, on this case right here, I got the time because she picked me up and I got out of jail with the piece of paper with this case from Wayne County Jail.
You were in custody for 5 or 6 days from December 11th to the 16th of 20. You were in custody on April 28th when I set a bond 4,010% until May the 5th. You've been in custody since Judge Kirsten set the bond of 10,010% the other day.
September 30th.
September 30. So I'm not saying you don't have some credit for time served.
And that's what I explained that he does. He
I
says that he had hold on, Morales, hold on.
So.
He says he had a judgment of sentence adjudicating the case on the concealed. I checked the register.
There is none.
No, it's the register, it's blank.
You have gotten yourself in all kinds of trouble because you don't show up.
No, I'm not disputing that.
You what?
I said I'm not disputing what you just said. I'm not disputing Your Honor.
You should have never, ever had to serve this kind of time on this case. Although I don't know much about you because you didn't bother showing up for your pre-sentence report. And if I let you go, you know what's going to happen?
I'm going to work.
You're not showing up again.
Your Honor, that's not. I don't believe that, but Your Honor, I've been working at Home Depot. I've been working at Smokers Depot on Liberty, Michigan. I can give you the phone number to my boss, and I've been working at Hammy's Pizzeria two places for the past 3 years. I haven't missed one day in 3 years, and I haven't had one police contact, not a civil infraction, nothing to do with law enforcement in 3 years, Your Honor. To me, that's fairly good for a guy like me that has a record like I do. I don't have not one police contact, Your Honor, in 3 years.
I'm just
In over
pulling
3
out
years.
your record here. Let me take a good look at your record.
In over 3 years, I haven't had nothing, Your Honor.
Right, but you've been a criminal for 35 years.
Thank you, Your Honor. That's why I'm saying that's pretty good for a guy like me that's been had a record like I did, and I've done good for the past 3 years. All I do, I don't drink, I don't use drugs. All I do is I work. Every day I get up, I go to work. That's what I look forward to.
All right, okay, settle down.
Well, I just miss it. I just like it's a good thing, Your Honor. People like me you don't experience that in your life.
I'm having a hard time understanding you. Just slow down and keep your voice up. Will you please do that for me?
Yes, Your Honor.
And you got quite a history here.
I understand. I know, Your Honor.
And nobody's going to think that you were a choir boy. You know what I'm saying?
Absolutely.
All right, so just let's get past this. If I knew that they recovered the property, that'd be a different thing.
They did, Your Honor. They got the property. It was in the car when I got arrested, Your Honor. It was just a lawnmower. That's on God's word. That's all it was. It was a lawnmower, and they got the property. I had no reason to lie to you, Your Honor. They recovered it. They gave it back to the
Settle
people.
down. Settle down.
Thank you, Your Honor.
Let me take a look at this. So you've spent some time in jail here because you did not bother showing up is the problem. But stop. I'm telling you to stop. Just don't interrupt me again. You got a warrant out of Dearborn, by the way, that you've had since 2021. See right on the fines and costs. I can't find that stuff now. No objection, fines, costs. Is that what he said? No objection, finding costs, sentence to run concurrent.
With the resisting injury, correct. So whatever jail credit he has, it sounds like he might have 3 small chunks.
Thank you. I got it. I need to talk to you before you leave about something completely unrelated to this, okay?
Yes, sir.
$14. Well, he's right. He hasn't been in a lot of trouble lately. All right, Mr. Baldwin, let's do an immediate sentencing. I can kind of read between the lines here. They caught him with the lawnmower. He says they recovered it. They didn't leave it in the trunk if they knew it was stolen property, so I can believe that. What do you want to tell me before I sentence?
I'm asking that the court sentence my client to both cases to a time served with jail credit to run concurrent. My client has already given a brief background history, recent history of what he is doing with his life. Apparently, he is, within the last 2 years, has been a lot of unproductive.
I know, but the problem is he's almost, what are you, 60? Looks like you're going to be 61 here shortly, right?
Yes, Your Honor.
Aren't you getting tired of doing this?
No, that's why I haven't done nothing wrong in 3 years.
All right, good. Anything else you want to tell me?
Well, whatever you do, I thank you for your time, and I'm sorry that I cost us court time, Your Honor. I really am.
Sorry that he what?
I apologize for the time I cost us court.
Don't worry about my time. That's what I
And
do.
to take something from somebody, Your Honor, I appreciate things a lot more when I buy it and
All
earn it.
right, good enough, good enough. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4 or 17 days on both cases, credit 17. We'll close those cases out, Lisa. Send something over and have them released in terms of these cases, if you would, please. Thank you very much. Have a good day, sir. Good luck.
Thank you, Judge.
You're welcome.
Thank you.
All right, let's change it up. We're going to head to Reno, but Reno with a little different flavor. This is Pro Tem Judge Steve Silva, so should have a different feel.
At the beginning of these proceedings, did you have a chance to speak to Ms. Wellborn, the attorney, today?
Yes, sir.
Do you have your rights explained to you? Do you understand feel you understand these proceedings, your options today?
Yes, sir.
All right, let me turn my attention to Ms. Wellborn. Ms. Wellborn.
My client intends to enter a plea of not guilty today, Your Honor.
All right, then Ms. Bennington, for the record, to the charge of disturbing the peace, breach of peace, how do you plead today?
Not guilty.
Not guilty? Okay, I'll take a not guilty plea. Let's discuss conditions of potential release. Let me hear from the city first, please.
Thank you, Your Honor. Here's reported domestic disturbance. It appears the defendant had called 911. When law enforcement arrived, she indicated that she and her ex had just been arguing, verbal only. It appears that the parties were in a prior dating relationship. They have 2 children in common. When they were speaking with the victim, he was a bit perplexed as to why they were called on that date. However, he had indicated 4 days earlier that there was an altercation in which the defendant had punched him in the nose. She apparently had observed him trying to communicate with an ex-girlfriend. This angered her. He showed law enforcement a date-stamped photograph of him having some injury and some blood to his nose. You want to give me just a moment, if I may?
Of course, please.
I'm sorry, Judge. I have the wrong case. I apologize for that.
This
is another.
Okay. Hold on.
I'm sorry.
No.
Hold on a minute. I have the wrong case here, Judge. I apologize for this. This was a reported domestic disturbance by nearby patrons who indicated that females and males are screaming at one another. The victim indicated that he had driven his ex-girlfriend home, indicated to her that there were some belongings, some packages inside the home. He then told her that those packages were not there. It sounds like that was where the argument had escalated. The victim had some injuries to his person, the victim had some injuries, as did the defendant. The defendant indicated that the father, as well as the victim, had dragged her out of the apartment complex. There were 2 individuals who had reported this incident, indicated that the defendant had pushed the victim, and there was a variety of stories, frankly. The victim had a couple different stories. From what I was able to gather, there looks like there was some mutual combat related here, hence the reason I filed the disturbing the peace. Your Honor, I do have some concerns given the defendant's criminal history. It's about 41 pages in length. It's concerning to the city.
Okay.
However, also given the allegations, Judge, I don't believe that a domestic battery could be proven here, hence for this reduction in charges. I'm not opposed to her OR release given the filing decision that I made here. I would ask for conditions upon her release that she obey all laws, consume no alcohol or drugs, and have absolutely no contact with the alleged victim. Again, I'm not seeking for any sort of enhanced supervision or testing, as there's no indication that she was impaired on this incident.
Excellent. Thank you very much. Ms. Wellborn?
We submit, Your Honor.
I presumed as much. I think that is a reasonable approach. I will allow her to be released on her own recognizance, subject to the conditions of obey all laws, strictly consume no drugs or alcohol. I need you to understand that my no drugs, no alcohol order includes the use of marijuana. So just be careful about that. I know it's a legal substance under Nevada law, but it is still a federally prohibited substance, and have no contact directly or indirectly with the alleged victim in this case. Is that Ross Canaglia Jr.?
Yeah, Ross Canaglia. And I go file a TPO down at the courthouse.
I cannot give you legal advice. However, there are resources down at the courthouse to help you figure out if you need to do something like that. And you're welcome to come down to the courthouse and seek those resources out.
Okay, thank you.
Okay, that'll conclude this case.
Okay, thank
you.
Your Honor, did you want to set that on the legal defender docket? And also, is there any testing?
No testing. None was requested by the city. And I think that makes sense given the nature of the offense. And yes, let's assign an LD in this case, please. Thank you.
Thank you. That will be November 13th at 1 p.m. with Ms. Wellborn.
Perfect. I'm looking for Travis Halden, please. Good morning, sir.
Good morning.
We are here in, looks like the number is cut off on my feed. Hold on 1 second. Give me just one. Do I have this as 25 CR 08824, Travis Antonio Hall? Looks like the underlying charge is use or possession of drug paraphernalia in violation of NRS 453566, coupled with an arrest for failure to pay or comply with court order post conviction. At the beginning of these proceedings, did you have a chance to speak with Ms. Wellborn?
Yes.
Do you admit or deny that you failed to pay or comply with a court order?
Thing is, it wasn't like, they let me go from a certain place. You see what I'm saying? So, but I didn't know what day I was supposed to come to court or none of that.
Okay, let me speak with Ms. Wellborn for a few minutes, see if I can get a little bit of light illuminated on what's going on here. Ms. Wellborn?
So our discussion this morning, Your Honor, was that he wants to resolve this matter today, and entertain an offer from the city as to how to proceed in his case. So it was my understanding based on our conversation that I think there just might be an understanding of that he needs to admit to the failure to appear first, and then we can get to the plea on the underlying charge.
He was found guilty of the underlying charge, according to my notes. This appears to be a post-conviction failure to pay or comply.
Judge, let me give you some background here. He was a community court participant. He failed to appear for a case status hearing with Jenny Perez on 7/28, which was hence the reason for the failure to comply. He has an outstanding 8 hours of community service, which we suspended. I'm sure Your Honor has unfortunately heard about community court and us closing our doors. It looks like he may also have another PCS case pending in the RJC. I'm going to ask that you simply revoke that 8 hours of community service, convert that to time served, and close this matter.
I think that is, assuming that he admits, I think that is an appropriate resolution to this case. Ms. Wellborn, or do you think we're all on the same page on how this can proceed?
At this time, I was looking at the wrong thing. My apologies. Yes.
No worries. Okay. Hey, Mr. Hall, here's what's going on. We think you didn't show up for community court. As you may or may not know, given forces larger than us, community court's doors are temporarily, God willing, temporarily closed. I'm looking for you to either admit or deny that you didn't show up for community court.
I showed up, but I left. We'll just say I didn't. It don't matter.
I'll take that as an admission. You came, but then you left before it was heard. And I think that counts as an admission. Sir, I've heard from the city, they're recommending time served is the ultimate outcome of your entire case. Before I convert your sentence, will afford you an opportunity to address the court. But since I'm inclined to give you time served, is there anything else you want to tell me, sir?
No, that's it.
All right. Time served is going to be the ultimate disposition of the underlying case. Thank you, everyone, for your hard work on this one. And best of luck to you, Mr. Hall.
All right.
Dennis Howard, please.
Let's change it back up, go back to Judge McNally, see what's going on.
Z. Johnson, 24B145 866A. Good morning.
Morning, Judge. Got the CEO on behalf of Ms. Johnson, state your full name for the court.
Jocelyn Johnson.
What happened here? She got show caused and didn't show up, and then now she paid her fines, right?
Yeah, she paid her fines, and I think another issue, Judge, with the community service. She completed that.
She provide us with proof of that, ma'am?
She showed me proof on her phone. I guess the letter that she sent to probation. She completed the community service at a place called Opportunity Center.
Who was your probation officer? Well, you weren't on probation. I just ordered 2 days community service. Who were you dealing with?
In the probation office?
Yeah.
I never really talked to anybody. She just gave me the information to fax my stuff over. But I never really sat down with the office.
All right. What'd she show you on her phone?
So she showed me proof of a letter that came from a place called Opportunity Center. And they stated that she.
Did they say she didn't do her community? At least I don't even see a show cause in here. Do you?
Yes, there's a show cause in there. I saw it. I think it's like 2 or 3 down, 2 or 3 pages down.
Yeah, I see it.
Thank you for calling. Elizabeth Wise.
Beth? Hey, can you come in here? I got a arraignment on a Jesselyn Johnson, Johnsson. You issued a show cause. It was non-probation case, but I ordered 2 days community service. Perfect. Thank you. Fine. Let me just get the probation director in here. She was the one that issued the show cause. It was issued back on March the 7th of this year. And it was for fair to pay fines and costs balance owing at the time of 5/25. Why did she not show up? Your client?
So I don't know if there was an issue with notices, going out.
The old post office through, where were you living? Where do you live now?
At 216 River, the same location.
Well, they didn't send them to Novi. Come on. Why didn't you show up? I hate that.
I'm sorry.
Well, why didn't you show up?
I honestly did not, I was not aware I was.
When you start with I honestly, and I have a feeling you're gonna tell me something that's not honest, that's gonna agitate me. Ms. Wilds, your name?
Elizabeth Wells, probationer.
So she paid her money. Her lawyer just told me she's got proof of community service on the phone.
I have it here, Your Honor. She provided it after the show cause arraignment was issued. I do have proof that she did her hours with MCOP, which is the opportunity program down in Monroe, and doing the 16 hours.
You're 26.
Yeah.
You gotta act. Where do you work?
Puff cannabis.
At where?
Puff cannabis, it's a dispensary.
All right, listen, here's what I'm doing. I'm gonna go ahead and I'm going to close the case. She's paid her money. You've got the proof. The defendant did community service, paid fines, costs. You gotta be a little more attentive, young lady. If you got any warrants, I'd strongly suggest you go take care of those, okay?
Yeah.
Good luck. Thanks. Thank you very much. Have a good day. Thanks.
Yeah.
Thank you. People against Kimbler. Mary Jo Kimbler. 25F244542. Mr. Boulahanis, good morning. Your name? Good morning.
Good morning, Your Honor. Greg Boulahanis on behalf of Mary Jo Kimbler.
Ms. Kimbler, nice and loud for me, ma'am. Your name?
Mary Jo Kimbler.
So you pre-tried this, and by the way, I need to talk to you about something unrelated to this when we're done, okay? Mr. Boulahanis?
Yes.
All right. So she's going to plead guilty to operating while impaired. The OWI will be dismissed. There's agreed upon cost of recovery of $225. Ms. Kimbler, if you plead guilty to operating while impaired, the possible penalties are up to $300 fines, 93 days jail, 360 hours community service. Court costs are all those 4 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? Do you understand that?
Yes, sir.
Okay, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. At a trial, you have the right to remain silent, right to question their witnesses, right to bring in your own, right to use subpoena powers of the court to bring in those witnesses. If you choose to remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. You're waiving the presumption of innocence, and we will not have a trial of any kind. Do you understand that?
Yes, sir.
The charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on South Wesley near Gibraltar Road in Flat Rock, August 6th of 25 at 9:36 p.m.?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, sir. A couple of,
Nice and loud, ma'am. Nice and loud for me, please.
couple of vodka and bloody, tomato juice. Bloody Marys, a couple of Bloody Marys.
Okay. And what else did you drink?
That was all, sir.
Were you at a bar or did you hand pour those or somebody else?
I hand poured them at the hair salon.
You work at a hair salon?
No, sir, I was getting my hair done.
I never quite heard of that kind of thing before. Anyway, so you hand poured Bloody Marys at the salon while getting your hair cut.
Yes, sir.
All right. And was your ability to operate the motor vehicle impaired because of your alcohol consumption?
Yes, sir.
Why were you pulled over by the police, ma'am?
Didn't have my lights on.
All right.
Headlights,
You think,
Your Honor.
all right.
Headlights.
And Ultimately, she was arrested, transported to the police station, underwent a blood draw, correct?
Yes, Your Honor.
And you stipulate that the reading was accurate of 0.129 on the blood draw, I believe it was?
Yes, Your Honor.
Ma'am, are you on probation or parole?
No, sir.
Anybody in the world force you to plead guilty?
No, sir.
All right, I'll accept your plea to impaired driving. Dismiss the OWI. Is this a first offense and only offense?
It's first and only offense, Your Honor, and my client's 69 years old and she has nothing, no priors, nothing.
I can see that. All right, ma'am, you have to come over here and be screened and assessed, okay? You're gonna have to come over here today and fill out a questionnaire and be interviewed. If Mr. Bulahanis, if you want to call probation at extension 245, again, 6710201, 734-671-0201, extension 245, they can try to make it more convenient. We'll set a sentencing date, and the sentencing date, they'll prepare a report and recommendation. You'll have the opportunity to review it with your lawyer. That will be on October the
16th at 8:30.
Good for you, Mr. Bulahanis?
Your Honor, is there any possibility I'm gonna be back October 15th in front of you on a hearing? Can we just?
Yeah,
do it
I don't
October
need,
15th?
that's fine. We can do that October 15th. You can come a little earlier than the hearing schedule. When do we set that for? 11?
11. Can we do it at 10:30 on the 15th?
Perfect. October 15th at 10:30. Now, Mr. Bulahanis, I was sitting in my office today. You and Mr. Urick were in here to discuss the motion. And I
Yeah.
see this Logan Davis pad. And I came to the conclusion, I didn't look at it. I just came to at first I thought it was Judge Kirsten's writing, but it can't be. It didn't look like it. Anyway, I think you left your pad here.
Okay,
So-
I'll come by and pick it up, Your Honor.
Okay. I
I'm
sure
sorry.
didn't want us to be looking through it, and you might have some other documents there that were yours. I don't know if they were your highlighting. If you were highlighting reports, I have a tendency to do that, and I know I did that in conjunction with reviewing that motion. But I
Yeah,
just wanted you to know, in case there was anything confidential, I told my recorder to put it in like one of those big yellow envelopes for you with your name on it.
yeah, I certainly appreciate Your Honor. I'll be by either later on today or tomorrow to pick that up. I apologize.
No, there's no reason to apologize. No worries. Okay? All right.
Okay.
Thanks a lot. Ma'am, good luck to you. We'll see you in a couple of weeks. But you gotta come over here the next day. He'll call and find out when it's convenient for you to be interviewed. All right?
Thank you, sir.
Good luck.
you very
Thanks.
much.
Thanks a lot.
Have a great day.
You too. Thank you. All right.
All right, as he's finished up, let's go back to Judge Mom. She's back out from chambers. Back out, but very muted yet. Let's go to Judge Boyd.
Am I pronouncing your last name correctly? Okay, yeah, no, if I'm not pronouncing it correctly, you need to tell me. That's the only way I will learn, and I'm trying to learn Spanish. Oh, Olade. Day. Olade. Okay. All right, the court is calling 2023 CR 11027C, State versus Juan Carlos Olade. Can I have parties announced for the record?
Megan Galloway for state.
Lauren Lupton from Spillada.
And are you Mr. Olade? Right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Juan Carlos Olade who was placed on deferred adjudication in 2023 CR 11027C for the offense of burglary of a building on January 4th, 2024 for a period of 3 years. Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Juan Carlos Palante did then and there fail to report to the supervision officer as directed for the months of February, March, and April of 2025. This violation of condition number 4.
How do you plead to that? True or not true? I'm sorry?
True.
Right, state.
Waive and abandon the
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
All right, is there a proposed agreement?
There is no support for the state's motion and adjudicate the defendant guilty, revoke his community supervision, and sentence him to 8 months in state jail.
All right, is that the agreement?
That is our agreement. On the docket, it shows 243 days in county, so we would just ask that he get credit for all that.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
Yes.
All right, then the court will follow your agreement. The court is going to find you guilty, revoke, sentence you to 8 months in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. If you're going to continue this way in your life, guess what's going to end up happening? A lot of judges are going to learn how to pronounce your last name because you're going to be in and out of somebody's courtroom, prison, or jail. If you don't want your life to turn out that way, then you're going to have to start making some changes. You understand?
Yes.
All right, good luck to you.
Thank you, Judge.
Thank you. Have a good one.
All right, Judge McNally's got a new contestant. Let's go there.
599 A, B, and C.
Thank you, Judge. Good morning. For the record, House Counsel Attorney Mike Bowman, please, 417 on behalf of my client, Ms. Fistful. Miss, can you just please state your full legal name for the record?
Tom Fistful.
Judge, for purposes of arraignment, on the 2 misdemeanors, my client stands me with formal reading the general information.
All right, so we have an OWI as I previously. We also have an MDOP and we have a valid registration. And so 2 misdemeanors, 1 civil infraction. Looks like she has a prior alcohol-related conviction back in 2016. Let me just check out this citation. You live still on College Street, ma'am?
Yes.
Okay. I'm gonna give you a $1,000 personal bond. You cannot leave, excuse me. You cannot leave the state without the consent of the court. Cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You do have to attend AA/NA or any 12-step recovery program twice a week. We're going to give you a form. Every time you go, you have to have the form signed, and every time you come to court, you have to bring the form with you. Also, no contact whatsoever with the victims in this case. So you cannot write, see, phone, text, email, or communicate with either. It appears to be Denolius.
Yes.
You shouldn't acknowledge anything here. Denolius Buchanan and or Jewel Buchanan. Do you understand that, ma'am?
Yes.
And also, you're not to enter or go near that address. I think the co-defendant said it was a little bit different, that it was 25627 or something. So you're not to enter the premises at maybe I'm wrong.
No, that was another case.
Yeah, you're right. Thank you. Thank you. Thank you.
That was grant license.
You're not to go near 24953 Mayfair in the city of Flat Rock, okay? So we'll give you a new court date. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one. And I'll give you a new date, and that will be on
October 16th at 10:15.
at 10:15.
Judge, let me just make sure if I'm here. Yeah, I'm here, Judge.
Okay? And I do want to still speak with you before you leave, okay, Mr. Baldwin? Pam, do you have any questions?
No.
Okay, I wish you well. Go down the hall, get your paper notice, fill out your petition for court appointed. Thank you. Joseph Madam Broski, 219F231964.
We enter the record, House Counsel, Mike Baldwin, for Boston.
Sir, your name?
Joseph Roscoe.
He was arraigned the other day. I set a bond because he'd ignored us for 6 years. He's going to plead guilty to no ops. They're going to dismiss the suspect. True?
Yes.
Is that what you want to do?
Yes.
If you plead guilty, the possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty at any time, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes.
For the charge, no valid operator's license on person, how do you plead?
Guilty.
Reoperating a motor vehicle in the city of Flat Rock, County of Wayne on November 9 of 19 at 2:10 in the morning on Gibraltar near Cahill.
I believe so.
Did you have a valid operator's license on your person? Sorry?
No.
Are you on probation or parole?
Yes.
Were you on probation or parole in November of
No.
19? Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No.
I'm gonna accept your plea to no ops, dismiss the suspend. He's homeless, he's not working, right?
Oh, right. I don't know. Yes.
He has an expired license as of September of this year. So we're hoping to keep that license.
You've been in custody since what day? The
Yes,
29th?
6 days jail credit.
What day was he taken into custody?
7.
Why would you do this? Why would you do this? This is crazy. Look,
This was never just.
sir, listen to me. You gotta get your life in order. Did you graduate?
Yes.
Why aren't you working?
I got fired and
Right, remind me, why'd you get fired?
just productivity and stuff, like
Probably not showing up, right?
here and there, yes.
He's been in custody since what day did you say? Saturday was the 27th.
I think he has 6.
You don't have any children or anything, right?
No.
You want to say anything?
No.
100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 6 days, credit 6. Please get your life in order. You're 25. You got 65 years ahead of you if you. But you can't be homeless, not working, and avoiding courts. Good luck. You'll be released if you have no other holds. Thank you. There's no reason for you to be in jail. None.
Mike, you got a second?
All right, he's finishing up. We're going to go to Judge Boyd, but before we go there, I wanted to point out, pay attention to the uploads that we do today here at TCF. I've got 3 videos going up. One involves a kind of disgusting living situation for a bunch of small children. Another one involves a bond reduction hearing for a guy who allegedly did some serious crimes against children. And then the last one that goes up today is one of the most brutal sentencings I've ever seen in a manslaughter case. So all 3 are worth watching. Pay attention to those. If you're a channel member, they're available to you already. If you're not a channel member, they'll be available as the day goes on. So be on the lookout. Let's go to Judge Boyd.
All right, so what are we here for?
We're asking to remove the ignition interlock during the time, we had a hearing on the MTR,
Mhm.
and he was continued on probation, but he was given time in jail, they said. And then after that, he's gonna go to inpatient treatment. So during the time that he's incarcerated, we're asking the court to remove the ignition interlock from his cars.
Okay, so here's my question. I see we have the 2024 CR 1737, but they also have him with a new case. Yes. Let me,
When
so,
Judge Angelini was here, we did a contested.
okay.
But I believe the condition for the ignition interlock was for the probation that he was on. And then it would be ordered as condition of bond.
All right, so here's the issue we're at. You're saying that he's supposed to be going into inpatient treatment?
After he serves the time in jail.
So just say the court's aware of like the case history. Well, Judge Angelini was here, we had a contested MTR. Judge Angelini found the new #1 true, and as a Simpson, he ordered the defendant to 180 days Bear County jail day for day, and then after that, the defendant is supposed to go to Safe PI, I believe, for treatment.
All right, so the only problem we're gonna have, because this new case is indicted, safety is not gonna accept him with an open case. I mean, he's just gonna be sitting,
I'm aware of that, and my intention is to work it out before the 180 days. Like, I'm gonna get it worked out before.
okay,
I just need a little bit more time to confirm if Mr. Valdez on
all right, so when did Judge Angelini enact the 180 days?
that. September 12th.
All right. All right, so how much time are you asking with the new case?
The new case had a setting.
All right, let me check.
It has a setting already.
Let me look in the system for what the setting is. That way there won't be any confusion.
Remember the date? October 27th, he said.
Yes. So do y'all, so we'll just come back on that on October
Yes.
27th. And he's currently in custody, not going to be released from in custody. And so you're just asking for the ignition interlock to be removed while in custody.
Yes.
Okay.
And I think no question about that. We're agreeable with that, but
Okay.
I think he was ordered on both cases. I want to make sure that
I'm not sure if it's on both cases
if
or
it's only
not.
one, they're gonna not remove.
Let me do this, just 1 second.
I do have it on the case ending in 1737.
Okay. Could you, hand me that printout, please? All right, counsel, and if you're in defense, can sign that, please. All right, Ms. Abrams, then the ignition interlock will be removed and reinstated upon release from custody.
Yes.
And then Norma, both of these cases, just put them on the same date, which is October 27th.
I will do that.
Oh, if you'll give it to Ms. Galloway to sign.
What date would he be coming back to?
He's gonna be coming back on October 27th. All right, take advantage of this, all right?
Thank you, Judge.
All right, you're welcome. Good luck to you. Thank you, counsel.
Yes, Judge, thank you.
Okay.
All right, friends, we'll do one last hearing over with Judge Mom to finish out the day.
Good morning. Your Honor, I discussed the case with Mr. after our discussion in chambers with the prosecutor and you. And at this point, we want to set a trial date, please.
Okay, are we doing and first off, Mr. Hearns, your name for the record, please.
It's Henry Hearns.
All right, thank you for dressing appropriately for court. We need the prosecutor in here.
Okay,
Can,
record, I'll get it.
perfect, thank you very much. There is no talking in court. Right, and Mr. Kaplan, your appearance for the record, please.
Thank you, Your Honor. Stephen Kaplan, on behalf of the people.
All right, thank you. All right, and so it's my understanding this matter is going to be set for trial. So I need to know, it says possible non-jury, but I need to know, are we setting this for a jury trial or a bench trial?
People are not demanding a jury.
Okay,
At this point, Mr. Hearns says a jury trial, Your Honor.
okay. And so then let's set this, we can do jury selection the afternoon of December 4th and jury trial on Friday, December 5th. Does that work for our docket?
You said jury selection on the 4th.
December 4th, yes.
Yes.
During what day of the week is
December 4th is a Friday, so that would be jury selection, I'm sorry,
That's
that's a Thursday. Jury selection would be at 1:30 in the afternoon. The jury trial would go the next day at 8:30 a.m. on a Friday.
Thank you, Your Honor.
All right, and then witness and exhibit lists and proposed jury instructions will be due October 24th. And then we will do an in-chambers conference to review that, and then that would be the settlement cutoff date as well on October 30th.
Oh, I'll be out of town on the October 30th, yeah.
November 6th?
Yes.
Does that work?
Yes. Yes, sure.
All right, so that would be, we have jury selection at 1:30 on that day on another matter, so we can do 11:30 a.m. Does that work for us, Ally? Oh, that's right. Okay, 8:30 a.m.
8:30 on November 6th.
Yes. For the in-chambers conference.
Very good. Your Honor, may I ask a question of the court?
Yes.
Your Honor, in the event the defense wishes to waive jury trial, will you allow that at some point or at any point?
I will, however, that will have to be determined and waived by November 6th. Yes, so then we know not to summons the jury.
All right, we'll discuss it. Thank you, and let that take roll.
And right. Now, I can also indicate, counsel, in the event, there's not going to be a waiver of the jury, and in the event there's not a resolution, then your client does not need to be present.
On the 6th.
Correct. The only reason your client would need to be present is if there's a resolution that's being placed on the record, or if there's going to be a waiver of the jury trial to be placed on the record. That's the only reason your client would need to be present. He can certainly be present if he wants to, but his attendance is not required on that date.
Oh, that makes sense.
Okay?
Yep.
All right.
Right. Thank you.
Bond and conditions are continued.
Thank you.
Thank you.
She finished off our day using lines from two other judges. The "thank you for dressing appropriately for court" from Judge Boyd, and the "bond will continue" from Judge Simpson. So that was fun. I hope you guys enjoyed the day. I did. I enjoyed it so much that we'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific, with Sidebar, so be sure to join us for that. Also, again, be aware of the 3 videos that are posting today. They are all very good. Again, if you're a channel member, you have access to those already, but be on the lookout for them. And yeah, we'll see you this evening. In the meantime, go have yourselves a great Thursday. Take care. God bless.